them at a home one night. Said, let's start with a kiss, it'll be alright. But now she might have a bun in the oven times two, and neither of them knows what to do. It's a blow by blow. Who's the daddy show? Is it twins from a blowjob? Oh, I don't know. Paternity tests and lawyers in sight. This crazy situation just ain't right. He swears he's not the one to blame. Says it's biologically insane. But she's pointing fingers, shouting loud, while the lawyers gather in the legal crowd. It's a blow by blow. Who's the daddy show? Is it twins from a blowjob? Oh, I don't know. Paternity tests and lawyers in sight. This crazy situation just ain't right. Now legal vices, he takes a drink, says let's settle this without the legal stink. He challenges her lawyer, please be better. We don't need another bad letter. So let's raise a glass to this legal brawl. May sanity prevail and pride take a fall. Twins from a blowjob, what have you to hide? But let's find some peace. Let your conscience be your guide.
Okay, everybody. Hi, it's me and Megan Fox. What's up?
Good morning.
We're feeling extra frisky, the both of us, if you can't tell.
No, just kidding.
Yeah. Not today. Not today. How's your day been for the first 30 seconds you've been awake?
Actually, I've been awake for a couple of hours now, and kind of stressful.
Sorry to hear that.
Kind of stressful. Wanted to roll back into my little burrito, in my burrito blanket, and just go back to sleep. But that was not in the cards because I had to come and hang out with you lovely people. But that's a good thing. I enjoy hanging out with Jeff and all the friends in chat. So at least it's going to be entertaining. I can stop thinking about all the stress.
Well, are we simul streaming over on your place?
Yes, we are.
Shit. I mean, hey, great. Yay.
All of my super chats belong to me.
Yep.
Well,
Yeah.
probably not.
I was actually,
Because we've established as of yesterday, they like you more than me.
clearly not. I watch your tug streams. I
Did you watch the
Yes.
new video, the new music
Yes.
video with you in it? Wasn't that
No, I
cute?
didn't see the introduction yet. I thought you were gonna ask if I watched the John video.
No.
I haven't watched the introduction yet.
Oh, okay. Well, whoever made, so the girl who wrote it and made the video, she did some AI renderings of you that are absolutely
Oh, dear.
adorable. No, they're great. They're perfect. They're
Mm.
perfect. It's in the song, the what's the name? Pecuniary.
All right. We'll see. Yeah, I just didn't get it today has not been okay. For those of you that are watching on replay, skip ahead like 10 minutes while we just sort through the bullshit. We'll just start
Maybe
fellowshipping
15,
and philosophizing
15
time.
minutes.
Yeah, we have to have our fellowship and philosophizing time here, otherwise it just wouldn't be a good stream.
Check it out. I'm wearing my I'm wearing vintage Johnny
Wow.
Depp
There
sweatshirt
you go.
from the Objection Hearsay. Check it out. I love this sweatshirt. It's my favorite. You can
For
get it on my
me-
merch store if you want to.
Yeah.
You can go to the merch store. We still have them. It's very cozy.
For me, I'm not doing so great right now, Megan.
Yeah, what happened?
What
You were
did
like
I-
texting me furiously late.
Just been
Day,
it's been
all of
a
it.
day. First of all, just a day at the office, and then this evening was the European Chamber of Commerce in Korea's Christmas year-end party. So I had to go to that, and of course it's a buffet, which just means I ate myself stupid.
Oh no.
And then they have the annual beer drinking competition.
Oh, did you
speed-
win again?
Like speed drinking, and I had to defend my title for the third year in a row. And yes, I did win the third year in a row. So my crown is, and I from like just, but see, this year was a little difficult because it's 500 milliliters. It's it's half a liter of beer, of like really bad beer, and so speed drank that, but. Like I thought it was going to be an easy win because my usual competition is in Norway right now, and some newbie came up and it was a dead heat. So
do we have video of this?
No,
oh,
I'm sure my friends have, and I'm
year.
sure I know. I'm sure I'll be getting some soon. I just don't have any currently.
So what you're telling me is you're soused?
No, I'm not soused. I'm just going to die because on the full stomach, you have to just just guzzle. Half a liter of beer, and then it's a tie, so you have to have the drink off of another half liter of beer.
What?
And so I'm just feeling bloated. I just want to die.
Isn't that what happened last year? You had a
it was a
drink off.
Yes.
And then you just barely lost last year, right? Or did you win? I don't remember.
No, I won. I'm the 3-year reigning champion. Like, I don't even like beer. I just have that weird talent of being able to guzzle drinks.
It's a very strange talent, Jeff, but I'm here for it. I'm here for it.
I'm very uncomfortable. As I said before we got started, there's going to be a lot of sighing today. I feel bloated.
Take some Tums and get over it.
Yeah, I just want
we have a very exciting appellate brief to read.
Yeah. I just want to lay down on the bed and put like 2 50-pound bulldogs on my stomach and just force the gas out either end. I just want to belch for about 15 minutes straight. Just like
that's a lovely mental picture, Jeffrey.
Yeah.
Thank you so much for sharing that.
Forget the alphabet. I want to do like Hamlet's soliloquy or something, the to be or not to be thing, and just the whole thing. Anyway. So here we are. All right, folks. Welcome to me and welcome to Megan. The Judge Lorax and the Derailer. We're here. We're here. And in case you're wondering what's happening, today is, I'll put this up here. Megan's people are going to wonder what the hell's going on, but we'll put this up here anyway, my people. No, it's day 74 of the Emotional Support Potato Pig Dog Gam. Will we see the Emotional Support Potato Pig Dogs? We need them because appellate brief, David Gingras.
Yeah, those are very good reasons.
Yeah, we need the Emotional Support Potato Pig Dogs. And if we get to the first hundy, that's when it comes down, and we reached day 75. That'll put us 3/4 of the way to triple digits. And if you don't know who Megan Fox is, shame on you. And if you aren't subscribed to her, double shame on you. Get over there, subscribe to her. And hey, people over on Megan's channel, come on over here. The water's nice. Just like click the subscribe button, and you can intercourse off back to Megan.
Yeah, definitely do that. Go subscribe to Jeff if you haven't done that already, because Legal Vices is fun and hilarious, and you definitely need to be. And he's definitely more entertaining than some folks on YouTube that I've seen who seem to think I have a voice like nails on a chalkboard.
Yes.
Nails on a chalkboard, reporting for duty.
That's us. Oh shit. Well, so again, we have that there. I've got the like and subscribe poll today up, which we're on page 35, I think, of 64. So we're like right about the halfway mark. The like and subscribe poll today over here on my old channel is, will we finish this today? Not a chance, says 60% of the people so far.
Not a chance.
Possibly, says 11 people so far. I mean, I'm sorry, not 11 people, 11%. That's different. It's probably actually less than 11 people at this point. And 7% say, yep, you got this. And 22% say,
the power of Christ compels you.
I hope so. All right, so that's the like and subscribe button. It's just a dumb thing to make you think about hitting the like button, hit the subscribe button for both of us. And if you are, I think you already subscribed to both of us, double check to make sure you still are, because YouTube is asshole and they think you don't want to be subscribed to us sometimes. They're idiots. And of course, we've got our first goal of the day up over here on my channel. So come on over here and help. Well, don't come on over here. If you're over there, stay over there. Well, who am I to tell you what to do with your Christmas? Do whatever the hell you want. Here, there, everywhere.
Do whatever you want.
It's like Huey Lewis. Here, there, and everywhere. Hip to be square. Like, subscribe, vote, do that. And then our goal today is...
Dude. Do you?
I used to. We would. If we get 50 super chats in the next 45 minutes of any color, any shape, or size, the goal is we will derail the stream to read 50 super chats. Let's effing go. Simple and to the point.
So now I need to set a goal. I haven't set one.
And plus, somewhere in the midst of that, doggo camel happened. So bear that in mind.
All right,
Megan. While you set that up, I'll bring stuff up here. Now, see, this is the thing. If you want your super chat read, super chat often, because there's an embargo on reading super chats till we hit the goal.
Oh, I see.
Well,
I see how this works.
Well, I mean, if it was Megan's channel, you'd never hear the super chat. You'd die of old age waiting. How do you do that? I mean, I get like weird. I start to freak out if I get more than 10 super chats backed up.
It is kind of nerve-wracking. It's true, and I tried last night to keep up, but
no, you can't with that.
I failed miserably. But that's a nice problem to have, so I'm not complaining.
Yeah.
I'm not complaining. My goal is 50 super chats, all the colors, 45 minutes, and if we get there, I will make Jeff read all of them.
Okay. I think that's okay. All right. Well, hell.
So he has to read all of my super chats too.
And I'll do it with grace and dignity as well.
Oh, too bad. Guess what?
What?
YouTube's not letting me set a goal, so you don't have to do shit.
What? Why?
Can't do it.
What do you mean? Why?
It does this sometimes. It's really weird.
Really?
It looks like I can set a goal, and then I go to hit the start goal, and nothing happens.
Oh, you got to wait like about 30 seconds. Sometimes it's really super delayed. Yeah, just click this. Just click the start button, and then wait like 30 seconds.
Well, I've clicked it like 6 times.
So stop clicking it. Click it once and wait.
Okay, I'm waiting, but I think it's frozen. Nothing's happening.
Maybe you clicked it 6 times. I mean, that's something to do with it.
Maybe.
Still nothing, huh?
Nope. Nothing.
Don't try.
I'm gonna refresh and try again.
Yeah, just click it once.
Okay.
I realized that too, because I was like, oh, I guess I just have to wait a while. All right. Well, in the meantime, just keep sending them here.
Damn it.
What?
Don't do that. Let's see. Wait.
Oh, they're sending to you. They're just not getting counted.
That's true. They're not getting counted.
Yeah.
No, I will count them though. Because I have a counter. I can see how many there are. I will count them. Well, actually, no, I can't because I see yours too. So I have no idea how many I have.
Oh, well, we'll figure it out. But see,
all right, see, I clicked it again. Oh, wait, did it work? Yes, it worked.
See,
okay.
He's got patience. But see, like Flux has never had the option to set a goal on hers.
Yeah, for some reason, they're only rolling it out slowly. And so some people have it and some people don't. And they're testing it right now. So we're supposed to be using it so we can give them feedback, I guess. I love it. I think it's a great idea.
Yeah, it's fun.
It's fun.
All right. Speaking of fun, I think we should come back into the appellate brief.
Fun? Did you say speaking of fun?
I did. Cringe face.
Didn't you know you're not supposed to have fun when you read legal documents, Jeff? You're not supposed to have any fun at all.
I'm sorry. We should just be somber.
Yes. Somber, boring, and monotone. That's the way that we should read legal documents because the law, is very
cockroaches
serious.
Are meant to be.
The law is very serious, Jeff. It's very serious.
It is serious. As you can tell by such things as this.
Twins from oral is very serious. Oh my God.
The before times.
Objection, hearsay.
Yeah.
How dare you?
The sidebars were so fun.
They were.
Remember when I put on my daughter's graduation robe?
Yes. Porcelain Thunder says, let's be honest, this case is hilarious. The case is hilarious, but appellate briefs aren't.
Appellate brief is not hilarious in any way.
The writing style kind of is sometimes.
Except for it's repetitive. It's very repetitive.
It's so repetitive. It keeps repeating itself. It's repetitive. So repetitive.
Are there exhibits? Are there any pages of like, memes or anything that,
I hope so.
or is it 64 pages of nothing but Rule 26?
There might be an occasional Rule 11 scattered therein.
Oh, right. Rule 11.
That makes them better because they're actually the same thing. All right. Well, speaking of Rule 11, that's where we ended up with the Rule 26. 26.
What?
Paging Dr. Freud.
That tracks.
Wow.
That tracks for this case. 26.
Hey, paging Dr. Freud. We talked about Rule 26 or Rule 11, whatever he wants to call it, how there was no way you can have sanctions under Rule 11 because they violated the rules. And we all know how bad that is, don't we?
Oh,
that's how bad it is.
That was the wrong button. Where's the rules button?
I was trying to hide my mistake, and now you ruined it. Now everybody knows it was a mistake.
This is a very
Shut the fuck up, Donnie.
We all know how important rules are.
Am I the only one around here who gives a shit about the rules?
Okay, so yeah, we know that. Okay, I'm willing to give him, but I would still like to see the response from Woodnick as to why he's entitled to this dismissal under Rule 11/26.
Is that what we were waiting for?
Well, that's first part of the argument. So
okay,
I want to see what his response to that is,
right.
Because he may have a good response, or he may go, "Yep, Gingras is right," but you know what? Doesn't matter.
I gotta put my footrest up for this. Here we go. Okay,
right.
now I'm comfy.
All right, where in the hell's there's the full screen mode. Booyah.
I have now 2 sick children at home, by the way, so if I get interrupted or have to leave, I need to
just a few
make
more to
them
go.
tea.
Yeah. All right, so I'm willing to concede that there appears to be a good argument that perhaps all of the rules for a Rule 26 sanctions motion were not complied with, and therefore may not be entitled to a sanction. I'm willing to consider the possibility, but I want to see Woodnick's response. But of course, as we all were pondering yesterday, so what? There was no Rule 26 motion pending at the time the sanctions were awarded sua sponte, or the court's own authority.
I think the only argument that might be worthwhile here, it's not the 26 or the 11 argument, but if it's true, what he said about the judge before issuing sua sponte sanctions is required to call a show cause hearing, that might be an argument if that's the real rule.
Yeah.
But we can't figure that out, though, whether that is the rule or that was footnotes or notes on the rules.
Yeah. So we'll have to see. We'll know.
But here's the other thing. Let me just put this out there too.
Put this out there.
Should he pull some miracle out of his backside and win this appeal, and then the whole thing it doesn't get dismissed, does it?
It would go back to trial.
It would go back to trial. Okay, so Jesus. So if it goes back to trial, I have every faith that it will be worse for her at the second trial.
But you know what that means? More breadstick money.
You know what else it means? I'm going back to Maricopa County. I'm going anyway. I mean, I'm going to go see my parents. But I was hoping that it would coincide with possibly a criminal trial involving this woman. Which if the county attorney decides to charge her, she still hasn't figured that out, I guess. But that's what I will be doing if that happens. So either way, I'll be headed back to Maricopa County because I want to see my lovely parents. But I'm hoping there will be, if there's a second trial, media van in the parking lot, breadsticks for everybody. Okay.
Awesome. But now let's all imagine that we're back in Maricopa County right now. we're in section D of whatever the hell part of this. The thing we're still in part 1, maybe we're in part 2. I don't know.
Oh, not
And
safe harbor again.
Let's see where this goes. I have 39 super chats.
Oh my God, I have one.
No, I mean
counting.
39 to the goal. I only have 11.
Oh.
But also, Sonia Chris gifted 10 Legal Vices memberships. So thank you very much for that, Sonia Chris. Nice. All right. Well, with all that out of the way, let's get going.
All right. Is it your turn to read first?
Do you feel particularly strongly one way or the other?
I do not. Why don't you go ahead?
Okay. And again, like we learned why apparently Rule 26 is not a viable option. But he also, and our response was there was no Rule 26 motion pending at the time. And he said, well, by any other authority, she can't give sanctions either. And that's what we're about to read. His arguments in that regard. See how this goes. And again, I am not an Arizona barred lawyer. I'm just north in Utah. So
and I'm not a lawyer at all. And apparently
you know less about the law than a dead dog.
That is what is being said. Yeah.
That's what some people have reported.
Less than a child, less than a dead dog.
At worst, but at best, not to the level of a 6-year-old. I believe was the quote. So
I don't know if I need to reiterate that I am not a lawyer at all. I'm just a medium smart journalist who sits around watching court cases all day. What do I know? Absolutely nothing. Just put it out. I'm just an idiot on YouTube. Untalented. I'm an untalented idiot on YouTube with a voice like nails on a chalkboard. So that you're tuning in here, I appreciate it. Thank you so much for tuning in.
You heard it from Megan Fox's own mouth. What do I know? What do I know? You heard it. Oh God. All right. So let's see why the judge has no authority anytime, anywhere, anyway to do anything sanction related in this case. Rule 26, safe harbor protects Laura from sanctions under other authority. Assuming the court agrees the award of sanctions under Rule 26 was improper, a different but related question must be addressed. Could Laura still be sanctioned under other authority, such as the court's inherent authority? Well, the answer to that question is no. Rule 26, safe harbor, shields Laura from any punishment arising from her alleged violation of Rule 26.
That conclusion is required by several. Wait, let me get my nails on a chalkboard voice ready.
Oh, wait. Can I do the impression of your voice first?
Yes.
This was the person's impression of Megan Fox. So this is my impression of the other person's impression.
That conclusion is required by several different points of law.
That sounded like Elaine. Oh, God. Okay.
That's how he made it sound. It was very much like the Wicked Witch of the West.
You know what really was annoying is that he had nothing terrible to say about you.
He's like, meh, I talked to him. He's like, okay. Yeah.
He seems like a nice guy. God damn it. You know?
I would rather have someone say something emphatic about me than just legal vices. Meh. Meh. At least Omar's dead to him, and you know less than a dead dog.
I like Omar. Omar, he's dead to me.
I'm just meh.
Yeah, legal vices. He seems nice.
Meh. So
All right.
That's me, Mr. Milquetoast.
That conclusion is required by several different points of law. First, as noted above, the central purpose of the safe harbor is to ensure a party can withdraw even frivolous pleadings without fear of life-altering punishment. That shouldn't even be a rule. If that is the rule, that shouldn't be a rule. They should retract that immediately. Why should somebody get off completely if they've filed something frivolous?
It ought to be a law to say they can't use the word withdraw in this lawsuit ever.
This quid pro quo benefits the courts and litigants by streamlining litigation and by making it easier for parties to drop claims early without risks of endless satellite litigation. Oh, you mean that like your client does? Endless satellite litigation, such as occurred here.
Indeed, the Ninth Circus has recognized the value of Rule 11. Can we stop talking about this? From the safe harbor allowing people to withdraw claims safely. Under the former rule, parties were sometimes reluctant to abandon a questionable contention, lest that be viewed as evidence of a violation of Rule 11. Under the revision, the timely withdrawal stop saying that of a contention will protect a party against a motion for sanction. So, if you withdraw early, that will protect you against the motions.
Against a motion for sanctions. It does not say it will protect you against the sua sponte anger of a judge.
What do you know, non-lawyer? He
True.
knows more than you. Yeah,
I don't know shit. This is also why, as noted above, the Ninth Circuit held in Radcliffe that a defective Rule 11 motion cannot be saved by converting it into a sua sponte motion based on a trial court's own authority. Even though Rule 11 otherwise permits sua sponte sanctions using OSC process, if these are the rules, they need to be seriously looked at because this is seriously confusing. This is ridiculous.
Well, the next sentence will help us, apparently.
Oh, but Jeff, remember, we can't really read through this because we're just skimming it. We need to open up Radcliffe and read every word, apparently.
That ain't going to happen.
See Radcliffe. In plain English, a safe harbor that provides no safety from punishment is no safe harbor at all.
I read in Reader's Digest once. Somebody said, a ship is perfectly safe in harbor, but that's not what ships were built for. Deep.
Very deep.
Deep. Well, see, again, this raises the same problem we talked about, I think, about 37 times yesterday. Nobody's converting shit. Nobody's converting anything. There was no motion pending at the time the judge said, screw it, sanctions.
Right. No motion pending. It had been withdrawn weeks before.
Yeah. Perhaps I'm wrong. I'm sure he'll tell. No, he won't tell me because I'm just meh.
Meh.
Not worth my time. Meh.
For that. Oh, it's your turn.
Tisk, tisk. All right, people. We're still like 37 away from reading super chats. Come on. Let's derail the stream. For that reason, Rule 26 safe harbor must be construed as not only shielding litigants from punishment under Rule 26, but also from punishment under any other authority, to the extent the punishment is based on the same conduct that allegedly violated Rule 26. Rule 26 safe harbor must be construed not only as shielding litigants from punishment under that rule, but also from punishment under any authority.
That's not a quote.
Yeah. I want to see some justification.
Where's the case law? Where's the...
Yeah, let's find out. That conclusion is required by both the language and intent of Rule 26. Well, I don't think it was in the language, and the intent can,
is subjective, isn't it?
Yeah. Yes. But also by the general legal principle long approved by Arizona courts that where two rules deal with the same subject, the more specific rule controls. Lots of cases here that I have not, nor will I ever read.
Well, then you can't possibly understand this argument, Jeff.
Well, here's a reason why you have these parentheses and quotes dealing with the subject matter of the case, so that the judge doesn't have to read every single one of these cases, and he can base his opinion based on what you put in the document.
Oh, no. According to, the lawyer who knows everything, in federal court, there will be clerks doing entire summaries on these cases for the judge. It's a federal case, Jeff. There's going to be clerks running around the courthouse doing David's work for him, apparently, is what I'm to understand.
They'll do a little bit of research and write some things for the judge. Here's what basically should happen. The judge will go, okay, yes, no, whatever, go write the judgment and I'll sign off on it. Yeah. Well, where two statutes deal with the same subject, the more specific statute controls. We interpret procedural rules according to the same principles we apply to the interpretation of statutes. Okay.
To be sure, as Clayton correctly argued in his brief opposing Laura's motion for judgment in the pleadings, many other rules, statutes, generally authorize sanctions for various different types of litigation misconduct. See ROA 111, arguing Title 25 now we're at Title 25, 25, 26, and 11. 25 contains at least 3 statutes that expressly instruct the court to award attorney's fees and sanction a party in response to unreasonable conduct in the litigation, and citing examples. Maybe we should look those up. You know, I'm going to look those up because you know why? Because he often does this where he will quote these rules and then he will leave out something important. 12, what is it? 12-3.
25-324.
Oh, 25-324.
And 25-415.
25-324. All right, hold on. I need to write down the other because so you can scroll on. And then there's 25-415 and 25-809. Okay.
At least on that one point, Clayton is right. Numerous other rules and laws of general application do permit sanctions, including, for instance, 12-349. But when a party claims a specific act violated Rule 26, as Clayton did here, in his counsel's very first filing,
which was withdrawn,
asking this court sanction petitioner under Rule 26. The question is whether a specific violation of Rule 26 can also separately be punished under some other rule or law of more general application, such as 12-349 or other laws mentioned in Clayton's brief, like 25-324. The old 25-324. Yes.
All right, do you want to see the law? I brought it up.
I don't know why. He just says the answer is clearly no, but let's go ahead.
I don't think it's clearly no. Okay, so the court from time to time, after considering the financial resources of both parties and reasonableness of the positions each party has taken throughout the proceedings, may order a party to pay reasonable amount to the other party for the costs and expenses of maintaining or defending any proceeding under this chapter or Chapter 4, Article 1 of this title. On request of a party or another court of competent jurisdiction, the court shall make specific findings concerning the portions of any award of fees and expenses that are based on consideration of financial resources and that are based on consideration of reasonableness of positions. The court may make these findings before, during, or after issuance of a fee award. B, if the court determines that a party filed a petition under one of the following circumstances, the court shall award reasonable costs and attorney. Shall is different than may to the other party. 1, the petition was not filed in good faith. That is what she found. 2, the petition was not grounded in fact or based on law. 3, the petition was filed for an improper purpose. She also found that, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. And then letter C here says, for the purpose of this section, costs and expense may include attorney's fees, deposition costs, and other fees, blah, blah, blah. And the court may order all amounts paid directly to the attorney, who may enforce the order under the attorney's name with the same force and effect in the same manner. Hey, this flies in the face of his argument that the fees must be awarded directly to the court and only the court.
Yeah. See, I think we're arguing two different sanctions here. He's still trying to keep it tied into Rule 26. Where here, Rule 25 is just basically the judge can do it if she thinks it wasn't filed in good faith. And
she didn't.
That, yeah, so.
She didn't think it was filed in good faith.
So,
all right.
Cough them up.
All right. And then I'll look up 415 too to see if there's anything else there. But
so you're not going to read. All right, I'll read.
Yeah, go ahead. I'll look. You read.
The question is whether a specific violation of Rule 26 can also separately be punished under some other rule or law of more general application, such as ARS 1259. The answer is clearly no. clearly no.
Oh my God, look at this, Jeff. Actually, this is amazing. This one's even better. This is even better. Sanctions for litigation misconduct. The court shall sanction a litigant for costs and fees incurred by an adverse party if the court finds that the litigant has done any one or more of the following. 1, knowingly presented a false claim. With knowledge that the claim is false. Can anybody say faked sonogram? Can anybody say false testimony about the where she went to Planned Parenthood? 2, knowingly accused an adverse party of making a false claim with knowledge that the claim is true. Violated a court order compelling disclosure, discovery. She did that. She didn't do disclosure. She, in fact, she then tried to say she went somewhere else on the day of the trial. So she violated disclosure. Unless the court finds that the failure to obey the order was substantially justified or that the other circumstances make an award of expenses unjust. If the court makes a finding against any litigant under subsection A, it may also impose additional financial sanctions on behalf of an aggrieved party who can demonstrate economic loss, institute civil contempt proceedings in its own initiative or on request of an aggrieved party, which with proper notice. Now, with proper notice and an opportunity to be heard is for contempt. I noticed that that was not specified in the sanctions for fees. 3, modify legal decision-making or parenting time if that modification, okay, that doesn't apply. C, because there are no children. For the purposes of the section, a false claim does not mean a claim that is merely unsubstantiated. And we definitely know it was a false claim here. This section does not prevent the court from awarding costs and attorney's fees or imposing other sanctions if authorized elsewhere by state or federal law.
Well, regardless of what Megan just said, he says, no, the answer is clearly no, Megan. Right here. The real Arizona lawyer says this.
Well, I only have the knowledge of maybe a 5 or 6-year-old. So don't take what I have to say or the Arizona law has to say seriously, because clearly this guy knows what he's talking about.
Or less than a dead dog. But having had a
Right.
6-year-old, I'm not sure which one of those two is the higher intelligence quotient, the dead dog or the 6-year-old.
Or the 6-year-old. But Jingy here says the answer is clearly no. This is so because a violation of Rule 26 must be governed by the terms of Rule 26, which of course would make sense if there were actually a Rule 26 motion pending, but there wasn't. Including the rule's safe harbor. Rule 26 is a highly specific law which addresses exactly the type of conduct Clayton accused Laura of committing, filing a baseless petition. By the way, wouldn't it be funny if this appeal would have worked if he never made Woodnick withdraw that Rule 26 motion?
Yeah.
Because he withdrew it because of Jingy's harassment.
Yeah. He's like, I could have won, but didn't want to. I think I could have won, but I didn't want to.
Yeah, I didn't want to go through it.
Oh, shoot. Chat. We're a little bit away from the emotional support potato pig dog cam. We are 36 away from my first goal. But how much time do we have? We're running out of time. We ain't going to make it. We got 15 minutes to get.
No, we're not going to make it. I only have 3 super chats. So, well, 4, actually 2 more that didn't count because I didn't have my thing turned on. Yeah. So 5, we're not going to make it today, but that's okay. Everyone's tired today. That's okay. That's all right. That means Jeff doesn't have to read my super chats.
Just means Jeff doesn't get any super chats. In addition to prescribing exactly that conduct, Rule 26 also sets forth a very specific process for how a violation should be addressed and how the violator may or may not be punished for the violation. Rule 26 could not be more directly applicable to the conduct in question. The rule therefore controls exactly how and when sanctions may be imposed and how and when they may not be.
As such, even if other general rules could arguably reach the same conduct, Rule 26 must control and must provide the exclusive remedy for a violation of Rule 26. But you made him withdraw it, so it wasn't on the table, David. When a statute creates a right and also creates a remedy for the right created, the remedy thereby given is exclusive. The rules of civil procedure have the force and effect of a statute. Cleaned up.
That means messed with or something.
Yeah, it means, yeah, he put that into his own words for some reason.
The limitation is implicitly acknowledged by general laws such as this one, which permits sanctions for unjustified actions, but only in a manner that is consistent with the more specific laws, like Rule 26. That limitation is, in fact, expressly written into 12.349, which allows courts to impose sanctions in general, but only except as otherwise provided by and not inconsistent with another statute, such as Section 25. It's like Rule 25. That's a different thing. Just saying.
Why are we whispering?
I don't know.
How many days have you gone for the doggo cam where it has not been interrupted?
We're on day 74 now. We're shooting for day 75.
We can't have a setback to 0 on the doggo clock. That cannot happen, chat. That cannot happen. Here's the good news. Jeff's goal is all colors of super chats. 99 cents counts too.
Well, and also we have got to the emotional support potato pig dogs, because if we factor in the 10 Saunier Chris gifted memberships and others, we
good.
Got, so that's where we are right now.
Awesome.
Where are we at here? Go away, stupid thing. Not you, Megan. This button. Ladies and gentlemen, well, I've already taken it down, but just in case you missed it here, today is day 74 of the emotional support. Well, yesterday was day 74. We had day 74, but today, right now, we have reached day 75 of the emotional support potato pig dog gam. For 75 days in a row, we've hit the goal.
That's awesome.
Yay. That's 3/4 of the way to triple digits. We should be to triple digits, I think, if I calculated correctly, in the second week of January. But so right now, for the 75th day in a row, keeping the streak alive, it's time to issue the command.
Release the hose.
And there we go. There's Strawberry.
Yay!
And there's overexposed Yoda.
look at Yoda's face. He's not sleeping yet. He's just staring off into space.
He's a little bit overexposed, but I'll deal with that some other time. Well, Megan.
MG's in the chat. He says, well, Rule 26 isn't a statute. It's true. And we have just read a bunch of statutes, and the statutes seem pretty clear. By the way, there's another one that he referenced, which was 12.349, unjustified actions, attorney fees, expenses, and double damages, exceptions, and definitions. And this one is pretty similar to the others. It's basically saying the court can assess reasonable attorney's fees and double damage at the court's discretion, double damages of not to exceed $5,000 against an attorney or party, including the state and political subdivisions of the state, if the attorney or party does any of the following: brings or defends a claim without substantial justification, brings a claim for delay or harassment, unreasonably expands or delays, engages in abusive discovery here. We definitely had that. The court may allocate the payment of attorney's fees among the offending attorneys, blah, blah, blah. Attorney's fees shall not be assessed if after filing an action, a voluntary dismissal is filed for any claim or defense within a reasonable time after the attorney or party filing the dismissal knew or reasonably should have known that the claim or defense was within the substantial justification. What does that mean, Jeff?
If I may be honest, I wasn't paying a bit of attention.
Letter C. Bring up my
now, what
screen.
have I done? I've done something now.
I don't know, but just share my screen.
I closed the window because you pressured me.
C, letter C. Attorney's fees shall not be assessed if after filing an action, a voluntary dismissal is filed for any claim or defense within a reasonable time after the attorney or party filing the dismissal knew or... Oh, so this means if she had filed a dismissal, let's say in October, when she got that HCG test that showed she was not pregnant, definitely not pregnant, the blood test, if she had filed for her dismissal back then, she could have avoided these fees because that would have been reasonable. What is unreasonable is hanging on through and testifying she was 100% pregnant in November after getting that test in October. That's what that means.
And I'm scrambling to find out the page where we were.
Oh no. It was like page 2036, I think.
It just felt that way. The answer is clearly no. We got past that one.
My YouTube studio fell down.
I panicked and clicked the wrong button because I do.
Runner X wants to know, do we get another get ready with me from Megan today? Do I not look ready to you? I think I'm offended. Do I look that untidy? Come on, my hair's brushed. I have some lip gloss, some Yips gloss on. What more do you need? And the lights are very dim for a reason.
What the hell is happening? We may be having a boomerish moment here.
My YouTube stream fell down. My YouTube studio fell down again.
Yeah. Well.
Please hold while Jeff figures out his boomer problem.
No, we just got this weird thing that
I'm streaming by candlelight today, chat.
How romantic.
It's dark in here because I didn't want to get ready. I was gonna just turn on my my avatar because she always looks ready. She looks great. Whoever the hell that is. Doesn't look anything like me, but I'll take it.
All right, let's see. Open that bad boy. And then open this one again. No thanks. View spelling errors. Oh, wow. Should we spell check him? All right. Well,
did you figure it out?
Yeah, it's being weird. Whatever. It's a stupid thing.
It's just pet Yoda while we're.
I was trying to bring up the judgment so that I could see exactly what issues were being talked about in this realm of things, but apparently I can't have two PDF files open at the same time for some reason. So
no, you can't.
And every time I try, it shuts the other one down too.
Oh wait, you mean you can't even have them open on your own computer screen?
Yeah.
That's weird. I use Foxit and it opens them as windows within Foxit, which works great.
Well, which I don't have, so.
Well, maybe that's your problem.
It is. Clearly.
Maybe you should have that.
I wish I would have, but I don't. Shut up, Megan. Don't judge me. All right, so back to page 36 or whatever it was we were on. No thanks for all your help. I'm talking to this thing, not you. Scroll in. Say something, Megan.
Hello. Sorry. Do we need some more music to fill in the silence?
No, we need you to talk and fill the silence.
Okay.
Like suddenly she's lost the power of speech.
Fine. All right. Well, if you have not seen the what I call the Northport nuke, I did drop that on my channel this morning. There is an interview with Crazy Connie. Those of you who've been following along with the What the Hales case, John Cook, in his deposition, someone was brought up by the name of Crazy Connie, who he claimed a bunch of things about. And Crazy Connie talked to me and gave me some evidence of what they were like in Northport before they ever met Jeremy Hales. And it's really enlightening. If you haven't seen it, you need to go over to my channel and click on it. The video is uploaded. It's 14 minutes. And it is called Northport Nuke. And it's just a little investigative journalisming that I do. I don't do lawyer stuff, but I do some journalisming here and there. And it's a pretty interesting find.
It is.
Go check it out when you have a chance.
Yeah, and there's a lot in there too. There's a lot in there to digest. Things that are said independently of anything going on currently in Otter Creek. Things that happened well before.
And by a person who doesn't know Jeremy Hales at all, never heard of him.
Yeah.
Not a clue.
Not a clue.
Not a clue. So it's pretty interesting.
All right. So much for me trying to be helpful. You're
All
welcome.
right. Somebody in the chat wants to know how many people I talked to regarding Northport. That would be proprietary work product information. So I'm going to keep that to myself. That would be confidential, but I have spoken to a few. Here, putting aside the fact, is that where we're starting at the top?
Yes, ma'am.
Here, putting aside the fact Clayton never actually moved for sanctions under any other authority, footnote number 3. Should we do that first? It is both axiomatic and required by rule that if a party wants relief, they must bring a motion seeking that relief. Well, yeah, but the judge also has the right to grant that relief, whether or not it's asked for. Explaining a party must request a court order in a pending action by motion unless otherwise provided by these rules. And there is an other provision in the rules.
There seems to be.
We just read a bunch of them.
Yeah, there seems to be.
After withdrawing his Rule 26 motion. Wait, let me start from it. I need to start from the beginning because there's a parenthesis here. Putting aside the fact Clayton never actually moved for sanctions under any other authority after withdrawing his Rule 26 motion, the trial court nevertheless concluded, like the lower court in Radcliffe, that sanctions could be imposed by under other legal authority without need for a motion and in a manner that was entirely inconsistent with Rule 26. That holding was it was under Rule 25. That's because it was under Rule 25, not Rule 26. We just read Rule 25.
Oh, and there you go, nitpicking again.
That holding was plainly wrong as a matter of law. There I go with my 6-year-old nitpicking. Plainly wrong as a matter of law. This guy and his language. This guy, plainly wrong.
Oh, okay. We do need to do a little bit of our own due diligence here, I think.
Okay.
All right, hang on. So he can be proud of us.
Okay, we're going to do due diligence. What are we doing? Are we reading Radcliffe?
No, hell no. We're reading the judgment.
Oh, good. Did you figure out how to open more than one PDF at a time?
I just put it in a browser window.
Ah, smart.
Yeah. I'm kind of that way sometimes. Let's see. Got to go down to page 14. Right. If we take this down for just a quick second and we put up, I guess we got to stop that screen entirely. Share this screen, the decision. Sanctions. This is what the judgment said. 26B provides that by signing a motion, it is a Rule 26. Okay, let's see how this plays out. By signing a pleading motion or other document, the attorney party certifies all this stuff. 26C provides that if a pleading motion or other document is signed in violation of the rule, the court, on motion or on its own, may impose on the person who signed it, a represented party or both, appropriate sanctions. So it does seem as based on 26.
She does seem to be using Rule 26, but wait a minute. Yeah. Rule 26C provides that if the pleading or other document is signed in violation of this rule, the court on motion or on its own may impose on the person who signed it, a represented party or both. So what are we not understanding about Rule 26? Am I not understanding something?
No.
Let's see.
Let's keep reading here.
26B.
All right. In this case, respondent filed a motion for sanctions pursuant to Rule 26 on January 3rd, arguing petitioner filed the underlying motion for an improper purpose without medical evidence to support her claim that she was pregnant and or that she was pregnant by the respondent. However, after significant motion practice between the parties attorneys, respondent filed a motion to withdraw. Okay. On April 3rd. So as of April 13th, there were no pending motions. While retaining his other claims, the question then becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion? Well, the judge seems to think so, apparently. As already noted above, Rule 26C expressly provides that the court can sanction a party for a violation on its own. What do we have 26C up there?
Yeah, I do.
Right, we'll get there in just a quick second. The court was unable to locate any decisions pertaining to whether the withdrawal of a party's Rule 26 sanctions motion could precludes a sua sponte court award, but as a matter of plain meaning and strict interpretation, it would seem not to matter whether a party ever files a motion or even whether the party does file a motion and then withdraws it. The court may still award sanctions as it deems appropriate based on the conduct it deems to violate the rule. The rule being...
Wait a minute. I have a problem here. So
Thank
this is
you.
Arizona Rules Civil Procedure 26, but this is about general provisions governing discovery, not sanctions. I don't know where sanctions is.
It's the Arizona Rules of Family Law Procedure.
Oh, that's what it is. Okay, hold on.
While she's doing that, we'll look at more of this. So if indeed, per Rule 26, so she's basically saying a court may still award sanctions it deems appropriate based on the conduct it deems to violate the rule. Indeed, if per Rule 26C, the court can at any time award sanctions of its own accord and on its own findings absent invitation, the withdrawal of a party's motion to do so would not seem to vitiate or in any way affect that power as a matter of plain logic. So if the court can do it on their authority, it doesn't matter whether or not they withdraw it. It makes a logical sense that they can still do it. So for instance, if the court were to here find the petitioner fabricated her pregnancy to provide leverage against respondent in order to secure a long-term relationship with him and all its attendant benefits, Rule 26 would appear without doubt to provide it the authority to order her to pay respondents reasonable expenses, including reasonable attorney fees, regardless of any prior filings by the parties. That is because that fabrication, if adjudicated as such, would have been the predicate for her initial petition and many, indeed, of all the motions that came after it. Do we have 26C yet?
No, it's
Right.
I'm having a hard time finding it. Which is weird. I know we've looked at this before, but I'm having a hard time finding it, and I don't know why.
Because you're not a lawyer.
Yeah, yes. Maybe you should look for it, Jeff, because I know we've read through it before, but I'm not finding it. It's only coming up as discovery, not sanctions.
Arizona Rules of Family Law Procedure.
26B, right? Yeah, it keeps coming up as discovery.
Whatever.
This is so strange.
Yeah, odd.
Are you
Arizona
seeing that?
Rules of Family Law Procedure, 26C.
It's all about discovery. Sanctions comes in at H. Here. Okay.
My family law procedure said 26 is additional filings.
I found under Rule 25, Section H, sanctions. The court may impose an appropriate sanction, including any order under Rule 16H against a party or attorney who is engaged in unreasonable, groundless, abusive, or obstructionist conduct in connection with discovery. See, this is still about discovery.
Yeah,
this is all about discovery. We don't have the right thing.
Weird. Well, whatever. Woodnick, hurry and file, dude. You're a real Arizona lawyer.
Yeah, why is Arizona law and rules so confusing? This is annoying that I'm having trouble finding this.
I was looking at a document titled Arizona Rules of Family Law Procedure.
Okay, the chat says 26C, not B. Okay, I'll try that.
Arizona.
This should not be this difficult to find. I'm beginning. If I ever hear Rule 26 again after this, I'm going to be very, very upset. MG, it keeps coming up as general provisions governing discovery. I did Google that. I too wish I was sleeping like Yoda.
Okay, I think I may have found this here somewhere else off-site. Access denied. All right, that's great. Sanctions. Arizona Rules of Civil Procedure 26. No, we need family law procedure.
This is really annoying.
Whatever.
You think we would have had this already? Like we would have looked at this already.
But why is it not coming up? Maybe she's misquoting it. Dun, dun,
I don't
dun.
know. That would be bad. Well, it would.
Yes, it would.
MG says it was the first Google result for him. MG, would you send it to me on Twitter, please?
Yeah,
Send me the
that would be
send me
good
the link.
because it ain't cropping up.
No, and I do feel like we should look at it. I mean,
Exactly, Strawberry. I will put you outside. Come here. Okay. All right. Anyway, while you're doing that, let's just figure out what else the judges got going on here. So anyway, indeed, if for Rule 26, the court can at any time award sanctions. All right. Although there is a dearth of case law on this issue, other rules confirm that the family court has the authority to award sanctions on its own. Okay, so we're going beyond 26, and 76.2a, for instance, provides that in a pre-judgment or post-judgment proceeding, which doesn't apply to this, the court can, upon its motion or its own initiative, impose sanctions if a party or attorney does one of these things. And the remedies available include, in addition to, wait a minute here, fails to obey a scheduling order, fails to appear, substantially unprepared, fails to participate in good faith.
MG says the link is in chat. MG, I can't find that.
Don't put it in chat.
Don't put it in chat. Send it to my Twitter so I can actually see it. I'm not going to find it in chat. Oh, wait, I see it, but I can't see it on YouTube. Jeff, it's in your chat.
All right, I got to open up my chat. Dang it, here he is just doing things for free.
So difficult. So difficult.
The court doesn't have to follow safe harbor. The link.
Do you see his chat?
Oh, there it is.
Okay, you got it?
Casetext.com, verifying you're human. Arizona law, family law. How did this come? This is weird. Didn't even come up. A, B, C. All right. So many windows. Now I have to verify I'm human over here on this browser, which I'm doing. Stop screen. Present new screen. How did this come up? Weird. This isn't even the same Arizona Rules of Family Procedures I came up with. As amended through August 22nd. Ooh, so there might be some newly amended things here. 26C, B, C. Sanctions. Generally, if a pleading, motion, or other document is signed in violation of this rule, the court, on motion or on its own, may impose on a person who signed it, a representative party, or both, an appropriate sanction. So, on the motion of Clayton Echard's side, or on its own. So there doesn't need, as she was just saying in her judgment a minute ago, there doesn't need to be a motion. That's how this non-Arizona lawyer reads it anyway.
Yeah, that's what it says.
Yeah,
but then I guess.
Well, let's continue reading here.
Okay.
We're both an appropriate sanction, which may include an order to pay the other party costs. Okay. Consultation before filing a motion for sanctions under this rule. So this is if you file a motion for sanctions. Now here it can either be on a motion or the judge can do it without a motion being filed. Okay, so attempt to resolve the matter. Matter's not satisfactory, resolve the consult. Motion for sanctions. A motion for sanctions under this rule must. That's what he was talking about yesterday and all this shit here. Yeah, okay. So
wait, what does that say? Letter B, letter C, 3, motion for sanctions under this rule must be made separately from any other motion. Describe this specific conduct, be accompanied by a Rule 9 good faith consultation. That's the thing that he said didn't happen. Yeah. And attach a copy. But does it matter that it was withdrawn?
No, it does. See, I'm going to say, what do I know? Because I'm not an Arizona lawyer. Wink, wink. It says here, the court on motion or on its own. If it's on a motion, the moving party must do this. And a motion for sanction must contain this. But all of this kind of goes out the window with
I think his argument though is because there was a motion, these appeal cases he found would apply because courts reversed judges doing this because of the safe harbor issue. My argument would be that it was withdrawn, so that becomes moot.
Yeah. So there is no motion. So the court, on its own, without a motion pending at that point in time, issued separate Rule 26 sanctions.
Yeah.
That's how I'm reading this.
That's how I see it also.
And if the court on its
court has
own,
all these, yeah, go ahead.
if the court, if you do it, base it on a motion, you have to do all this. If the court does it on its own, there's nothing here that says the court must do it like this. The court can just do it.
Yeah. That's what it says. That is what it says. I mean, obviously he's making his arguments and it will be heard and they will decide whether or not he has any merit to it. But I'm still confused with his argument because I don't see how the Rule 26 motion that was filed and withdrawn isn't moot. I don't see how it should be subject to any of this at that point.
Well, and the judge kind of addresses this. Well, not kind of. She does address this exact thing here in the next paragraph of her ruling. This is where she's saying the remedies available. They can do this, but additionally, as is evident from their near textual identity and per the Arizona Family Law Rules Handbook, the AFLRP 26 is based on the Arizona Rule of Civil Procedure. They compare the rules. Rule 11, cough, 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 also expressly provides that in the event of a violation, the court on motion or on its own may impose on the person who signed it. This is basically the same wording. And then it says here, this lends credence, she says, to the idea that the family court's inherent authority to award sanctions under 26 should not be read to be limited by the course of the case or by the litigation strategy pursued by the parties. The power is there by rule and can be used by the court when necessary and appropriate.
I do wonder why choose. Oh, here she's gonna note 25 as well. I was just gonna say, why choose 26 when you could choose 25, which seems even easier. I don't know.
That's just for the paternity issue.
Oh, that's a different Rule 25. Oh, geez, all these rules. Why are they why are they all different?
There's lots of rules because they're different types of courts. But anyway, good Lord. She is saying what we've been saying. The court can do this on her own. The court has the authority, the power to do this, irrespective of whether a motion is filed. And the court's authority isn't tied to this motion. There was no motion pending as of April 3rd. So this happens all after April 3rd. There was no motion pending. The judge can base it on that rule. But Gingras is saying it was the interpretation and the notes, the preparatory notes or whatever the hell he was talking about, where they just say, here's what we were thinking when we made this rule. He's saying that should preclude the judge from doing this. I think he's wrong. But what do I know? I'm not really a lawyer. I think this is where Woodnick's going to go with it. So I think we're in good hands, Megan.
Okay, we have till the 20. It's due on the 24th, I think, the response. Yeah. So it's coming up.
23rd,
Christmas
24th.
Eve. Yeah. We'll be getting a response for Christmas.
Yes, we will. Oh, and before we get into this, we failed on both goals, people. Yeah, you failed. I only got 21 out of 50. How many did you get, Megan?
6.
All right. Well, there's not many to read then. Wings 10. Got to start somewhere. Let the derailing begin. We're not going to get derailed. Nope, you didn't want it. Wings with a 2. Yes, let's go. Tonsil twins. Cindy Brown. I'm doing it. Cindy Brown again at the $2 again. Megan.
The Magdalorian, thanks for the 5. From one curly girl to another, need your overnight secret. The hair looks great. When I straighten it, all I have to do is just sleep on it for a few days and it continues to stay flat and straight, which is nice. So there really is no secret. Just
baby, let me sleep on it. Keep your answer in the morning. Winks with $5. Thank you so much, Winks. Oh no, not a bad day for Jeff. Send the breadstick money. You didn't do it. Shame. No, just kidding. Thank you, Winks. You're awesome. Cindy Brown with it says again. If you know, you know. Fahrenheit. Oh, Fallen Hero. Fahrenheit 451. Hey, what's up? Fallen Hero 4567 of the $2. Thank you, Munchley. Jonathan Irwin. Megan on time and with her glasses. Well, the only reason we're both on time was because I set the stream to start 15 minutes late.
True.
So that's why we were on time. Whatever it takes, we're going to get the win. Jonathan Irwin, thank you so much. Fake Laura Owens. Let me know right before you finish. I don't want to get pregnant again. Challenge accepted, says, hey, Joe, fake Laura Owens 5 minutes in the penalty box for instigating. Challenge accepted. Hey, Joe, what's up? And
good morning in the clouds 4. Thanks for the 5.
also Megan.
Hey, Joe, thanks for the 5. Let's go.
Island, having a stupid week. Need support potatoes ASAP. We have stupid support potatoes to help you through your stupid week. And Sonia and Chris, we lauded you for your 10 Legal Vices memberships. Thank you so much. Megan.
In the clouds 4. Thanks for the 2. Thanks for the laughter.
Yeah. Fake Laura Owens again. Safe Harbor. Sounds like a place I should have gone instead of Planned Parenthood. They open on Sunday. Thanks. If by magical chance a new trial is granted, would they allot more time than the original? Who knows? Actually, no. Probably the same. I don't know.
2 hours was not enough.
Sometimes 20 minutes is enough. Super sticker from Hey Joe. What's up? I'm sorry, that's yours, Megan.
Hey Joe, thanks for the 5 super sticker. Appreciate you.
Also, Megan.
Fake Laura Owens. We don't use the word withdraw around here. How do I get fake pregnant if we start withdrawing?
also, Megan.
Fake Laura Owens. Thanks for the 5. Safe harbor. Clayton thought my mouth was a safe harbor, but nope. Twins. It's good. It's good. So good.
Icky. Island. Somehow I got lumped in with this cult and I didn't get love bombed or anything. Don't get love bombed. You get twins that way. Seems like a scam. Not even a special job or a weird haircut. Well, I'll give you a special job. Winks for the we want doggo. Him. Please. Thank you so much. Fake Laura Owens for Megan Fox.
You're right. It's too early and I'm tired and sore from watching Netflix with company last night. No pony riding for me today.
Laura Knighty appears to be broken in chat. Wings. Yay. Thank you. You're so welcome. Fake Laura Owens once again for Megan Fox.
Dim lights. That's why I go to Iceland on dates. I look good everywhere there.
Yoink. Island again. I know I haven't technically met Yoda, but that's parasocially irrelevant.
Let's not focus on that.
More importantly, I feel like Yoda really gets me. It totally gets everybody, man. It's just a deal. Lady K, Texas for Megan Fox.
Megan, the B3 chicks just said real women don't beg for money. Ugh, they slay me. Well, I do. I'm begging Megan, and I'm here begging for your super chats every day on the internet as I bring you entertainment and news and legal documents and stupid jokes, because that's what we do here. And yeah, I think begging for super chats is perfectly fine. That's all I have to say about that. That's how this YouTube thing works.
I thought one of them liked it when people begged her to do things to them.
Well, they've been begging for money for a fence and other things, and now a cruise. I guess there could be cruise. And Bruce's airfare to Pensacola because the judge wants to spank him in person. So, you know,
I think one of them can take care of that for him.
That's true.
He's good at that.
That's true. They can put him through an entire humiliation ritual.
Well, I think being on this case is that. You know,
that's been meeting that goal. Fake Laura Owens, thanks for 5. Flat and straight. We have so much in common. Megan's hair, my chest and butt. Penalty box. Penalty box.
Oh, grief. And finally, Jenna Ring. Thank you so much, Jenna Ring, for the $5. I don't care what they say. I love Megan's laugh.
Well, you just love nails on a chalkboard. That's what it is.
Yeah. Megan Fox. dumber.
Higgles says, no one goes a begging quite like Megan.
Super chats are here. Take your pick. Can't take the derailing. Oh, we're not derailing. We're going to get right
There's
back.
no derailing. There's no derailing here.
So what we've decided is he may be obfuscating here. He's trying to Jedi mind trick us, I would say, because reading the rule, reading the judgment, and not getting bogged down by case law and all these other lawyers worry about. Just looking at things on the face of it themselves, I think the judge has a pretty compelling argument. Says it may on motion or their own authority. Now he's saying, of course, you can't convert it. It wasn't converted. This judgment for sanctions came down way after the rule was. I mean, the motion for sanctions was withdrawn several months actually, and of course he's relying on the creation notes, the council, the committee's notes to say, well, you shouldn't be able to do anything. Which, as we've been saying, is kind of weird if you say just because someone withdraws a Rule 26 motion or doesn't comply, you can never, ever sanction them for anything ever again. It's kind of weird.
I wonder if, his argument doesn't even really make logical sense, because let's think about this. If Rule 26 says that the court has the authority to either grant a motion for sanctions under that rule or act on her own sua sponte, then I don't really understand the appeals rule.
Both of them are under the rule. Both of them are under the rule. Either by motion under the rule or she under her own authority. And if you do it by motion, you have to follow all those steps. If she does it on her own authority, there are no steps in there that she must follow.
Yeah, that's how I'm seeing it.
Yeah.
I feel gaslighted because I'm still
gassy because I had to guzzle a liter of beer before I got here. Yes, but
I feel like this entire appeal is just an exercise in gaslighting. That's how it feels. Because I'm starting to feel like I'm going crazy.
Going? Okay, let's continue. Yes, going, Megan. Yes, going. Cringe face. The limitation is implicitly acknowledged by general laws, which permit sanctions for unjustified actions, but only in a manner consistent with more specific, except as otherwise provided by and not inconsistent with another statute, sort of like the part of Rule 26 that says by their own authority. So here you go, Megan. Pretend you're right and just read.
Here, putting aside the fact that Clayton never actually moved for sanctions under any other authority, why would we put that aside?
Wait, did we read this one? We already read this one already.
We did.
Yeah.
Oh my God, did he do another copy paste problem?
No, I think I just did a scroll problem.
We just lost our...
Yeah. All right, this is where the holding was wrong. This is where, because if a party withdraws a pleading in response to a threat to seek Rule 26 sanctions, the safe harbor provision of Rule 26 must provide meaningful protection by allowing the error to be corrected without sanctions under other rules. This safe harbor is needed to ensure the rule functions as intended, incentivizing parties to promptly drop claims when challenged without fear of life-altering punishment. As a result, if a party invokes the safe harbor Rule 26, as Laura did here, but is then punished under other authority for exactly the same conduct that violated Rule 26, the safe harbor will literally be stripped of all meaning. This court must firmly and clearly reject that outcome. Okay, that's a argument, but the court can say, yeah, even though they don't want you to be sanctioned, I still think you should. So boom, drop the ban hammer.
Right.
Well, that's the end of that argument. Huh. Okay,
Finally.
That was weird.
How much you want to bet he goes back to it?
Rule 11, safe harbor.
So the trial court committed structural error requiring automatic reversal by performing an independent investigation. Oh God, here we go. Independent investigation into the facts. Citations to record and standard of review. Laura raised the issue of structural error in her post-trial motion for new trial. The factual basis for Laura's argument, misconduct by the trial judge, was also raised in her notice of change of judge for cause and supporting affidavit of counsel.
Okay, before we get going, I just want to summarize something real quickly here. His arguments that the Rule 26 thing, the sanctions can't be given under the rule based on the motion of Clayton Echard. I'll give him that one. Okay, correct. But that motion was withdrawn. So that argument is completely useless and unnecessary as far as I'm concerned. The second one, converting he said you can't convert the Rule 26 failure into a judge-related thing. Okay, fine. Let's give him that because that's not what happened here. Nothing was converted. There was no pending Rule 26 motion at the time she handled it. So it wasn't converting his motion into a judge motion. In April, it was gone. And what was it, June? She said sanctions. So 2 months later, completely independent of what was going on over there, the previous Rule 26, she handed it down. And that was the weakest argument he made as to why she can't do that. So I think all of those arguments, that was the weakest one, and that's the only one that really I can see holding water. And he spent 39 pages minus the index. That should have been about maybe 4 pages. I would say 3 pages long.
Mm-hmm.
That entire argument about Rule 11, Rule 26, and the judge's own authority should have been maybe 3 pages long.
Lauren Knighty just said something hilarious in chat. I can't find it, but she said stream hopping in search of a childlike understanding of the law.
Well, you've gone to the right place.
Isn't that what Jesus said? Didn't Jesus say we should have a childlike understanding of things?
Well, you've got it mastered then.
Be more like a child.
Megan's got law mastered then because she's got a childlike understanding. Less than a 6-year-old and a dead dog. Exactly. All right. Continue. I guess it's my turn now. Fudge dog. Baggy, you doing? Come here. And we'll put you outside. The notice of change of judge was denied by the presiding judge on August 13th, 2024. And the motion for a new trial was denied by a one-line minute entry, I guess, entry order dated September 6th.
As for these points, the standard of review is de novo. We review both constitutional and structural error claims de novo. We would defer to the court's factual findings, but we review de novo as ultimate legal determination. By the way, the chief judge who looked at the motion to change judge, the chief judge said it was not structural error. The chief judge said it would actually have made no difference whatsoever. And that's the same thing he's going to run up against here when they look at this. Lauren said, Jesus said his dead dog knew more about the Bible than his disciples. Who knew?
See, this is what he's banking on. The standard of review is de novo. I mean, like completely brand new. We have to do, and he's thinking, okay, maybe they'll look at it differently the next time. But maybe not. Discussion. Discuss amongst yourselves.
Discuss.
Uh-oh.
Talk about
assuming this
daughters.
Assuming this court agrees with Laura's interpretation of Rule 26, clearly doesn't. The inquiry ends. Dun, dun, dun. The safe harbor is dispositive of this appeal, and the court need not consider any other issues other than Laura's request for fees. However,
if this court chooses to part company with the extensive authority supporting Laura's interpretation of Rule 26,
see you later, extensive authority supporting Laura's.
The lower court's judgment still cannot stand. This is so because, as explained in Laura's notice of change of judge, the supporting affidavit and Laura's motion for new trial and other relief, clear and irrefutable evidence showed that the trial judge committed structural error. Well, it was refuted by the chief judge, so I don't know how he could say it's irrefutable, resulting in a violation of Laura's constitutional right to due process. This violation occurred when the trial judge performed an independent and undisclosed investigation into the facts of this case, of which he has no evidence, and made post-trial findings based not on the evidence admitted at trial, but rather on social media posts published on the internet after the trial concluded. Yeah, he can't prove that and didn't prove that in any way.
I say, prove it. Prove it. I get a footnote. I get a long footnote. It's a foot-long footnote.
Did we miss it? Where is it? Oh, there it is. I see.
Although the presiding judge rejected this argument insofar as it was raised in Laura's notice of change of judge, if this court remands for a new trial, which it should not, given the primary argument and relief raised above, Laura would be automatically entitled to a change of judge as a matter of right. For that reason, it is not necessary for this court to separately decide whether the presiding judge erred when she denied Laura's
Oh,
notice
it's
of
not?
change.
It's not? It's not necessary?
It's not.
Really?
He said so. He knows more than you. He's an Arizona lawyer.
Right. And I have a childlike understanding of law, so
Yeah.
what do I know?
You
I would think
sweet
it would be
summer
necessary,
medium
though.
smart child.
I think it would be necessary, though, to look at why the chief judge ruled the way she did.
Because that relief is subsumed within the structural error argument raised in Laura's motion for a new trial, which this court must review de novo. In other words, remanding for a new trial would automatically entitle Laura to a change of judge as a matter of right anyway. So the court need not decide that separate issue. So give it a new judge and give it new eyes.
It's convenient. I mean, yes, that would happen as a just automatically, but still, I think it's funny that it's almost like, don't look at what the chief judge said. We don't need to do that.
Pay no attention to the judge behind the curtain.
Pay no attention to that. We don't want you to see her explanation.
Although the presiding judge rejected this argument, insofar as it was raised in Laura's notice of change by judge, and although the trial court denied Laura's motion for a new trial, structural error is subject to de novo review. How many fucking times is he going to say that?
I don't know.
Jesus. It's like he's writing for a judge to hate him and just throw this in the garbage can.
Yes, that's his writing style. His writing style is to piss everyone off and make everyone hate him. That is also his talking style, his speaking style, his social style. Yeah. To help
Don't
summarize,
compose to fail. That's like, just don't compose to fail. I'm going to write this in as annoying and repetitive manner as possible so everyone will love me.
Look at me, Daddy. I'm a real judge now.
Look at me, Daddy. I'm a real Arizona lawyer.
Look at me, Daddy.
With an AR-15.
To help summarize, he still doesn't understand YouTube rules. Like, he's still live streaming with firearms on screen. It's incredible. We've only said it how many times now? But keep going, David. Keep going. To help summarize the structural error problem, clearly, I love it when he uses words like this. Clearly, the single most important
Jedi mind tricking you.
And most aggressively disputed fact below was the question of whether Laura was ever actually pregnant. Laura claimed that prior to filing the establishment petition, she tested positive for pregnancy 5 times, including the surprise unannounced test given to her by Clayton, which he later confirmed in writing was positive for pregnancy. Indeed, Clayton not only admitted seeing the positive test, he took a photo of the positive test and emailed it to Laura. That still doesn't mean she was pregnant. None of that means she was pregnant.
They're not positive for pregnancy. They're positive for the possibility of pregnancy.
Uh-huh.
That's why you actually go to the doctor and get prenatal care, especially if you're fucking rich. Doesn't make any sense.
No sense at all. It doesn't meet any reasonable standard by anyone's definition.
Do you want to read the last 2 words there?
Oh, emphasis added.
Emphasis. Despite these compelling evidence of pregnancy.
Compelling my ass.
You heard it here. The only thing he's compelling is Megan Fox's ass. Despite compelling Megan Fox's ass, that is not. Look, peeing on a stick just makes you go, "Oh God, we better get to the hospital."
Yeah, got to go confirm this.
Yeah, Clayton theorized Laura somehow faked the pregnancy as a way of trapping him into a romantic relationship. Now, that's what the contract was for, to trap him in a romantic relationship. To support his theory, Clayton retained a medical expert, Dr. Samantha Deans, an OBGYN who previously worked for Planned Parenthood on the East Coast.
In her expert report, Excuse me. Dr. Deans never claimed Laura was not pregnant. Instead, Dr. Deans expressed an opinion that a woman cannot be regarded as clinically pregnant unless the pregnancy is confirmed by an ultrasound or other clinical signs of pregnancy. Based on this strange technical definition of
You mean the definition is strange and technical?
Of clinical pregnancy, Dr. Deans opined because Laura did not provide a verified ultrasound, that meant it was impossible to know whether she was clinically pregnant, implying Laura was never actually pregnant at all, whether in the clinical sense
I would suggest that submitting a fake and fraudulent one might sort of, imply that she's not.
It might lead one to believe that she was never pregnant. Yeah. And this is from Dr. Deans's report. We cannot confirm by any objective data that Miss Owens had an ongoing viable clinical pregnancy at any time in the last year. Clinical pregnancy is defined as a pregnancy diagnosed by ultrasonographic visualization of one or more gestational sacs or definitive clinical signs of pregnancy. In addition to intrauterine pregnancy, it includes a clinically documented ectopic pregnancy. We have received no verifiable documentation of a clinical pregnancy as defined.
Oh, pish
Seems
posh.
Reasonable to me.
Pish posh, Megan. Just pish posh.
It must be my childlike understanding of things that I don't understand.
As they said in one of the best television series ever, Succession, words are just complicated airflow. What does this super qualified OBGYN know about pregnancy?
What does she know?
Derp, as the kids say. This, according to Clayton, the existence or absence of a verified ultrasound, I would even settle for a non-fraudulent one. I'd settle for a not faked, stolen from YouTube ultrasound. How about
Lauren says they have a childlike understanding of childbearing. True.
Mommy, I just gave him a blowjob. Am I going to get pregnant now?
Yep. That's not how any of this works, Laura. KY says it would be more entertaining if Laura Owens had met Jeremy instead. Can you imagine? If the timelines intersected and Laura Owens was Jeremy's neighbor instead of Lynette. Yikes.
Yikes. Hashtag yikes.
Hashtag yikes. Yeah. Can we please just remember that this man who wrote this appeal is the same lawyer who wrote hashtag me too in a filing, and yikes.
Yikes.
And he wants to tell everybody else how to be a professional lawyer. Give me a break.
LOL. Just one small problem. What?
He also said yesterday he's not going to make another video for a very long time. I give him 24 hours.
Yeah, I was going to say, is it dropped yet?
I feel like we won Jingy in a very nasty custody dispute from Woodnick's office, and I feel like we got the dog, that no one wanted, that craps all over the floor, and it's time for him to go back to his visitation with Woodnick. It's time for Woodnick to take custody of this man again. I can't deal with him anymore. I don't want him.
Non-house trained things. It's Dave Neal.
He's in my house now, and I want him out. Hi, Dave. Hey, Dave. He's shitting all over YouTube now, and it's enough.
See, I just, the more people show up, the worse I feel.
Why?
Laura and I'm dealing with her. Megan Fox sounds like nails on a chalkboard. She's dumber than a dead dog and a 6-year-old. Dave Neal, he's just Dave Neal. Legal Vices, meh.
Jeff's feeling very left out of the vitriol that's being spewed from a certain corner of YouTube.
Yeah.
And Omar is dead to him.
Yes, and Omar's dead to him. Legal Vices, meh.
Seems like a nice guy.
Yeah, just, there's vitriol being spewed around, and, just don't get it in my eye.
Yes, this lawyer is not house trained, Aaron. That's correct. And I'm really tired of him shitting all over YouTube. And I would like Woodnick to take him back now. Could he do his part of the visitation? I feel like Woodnick had him for 6 months. We are now had him for 6 months, and it's time to go back for 6 months into the court system.
Legal vices. Meh. Well, see, it's like again, I don't know who said this, but it was a quotation that when one is pitied, one ceases to be an object of fear.
Look at Dave. Look at Dave's comment.
Eyeball twins.
Don't get eyeball twins. Don't get it in my eye. That leads to twins.
His weirdly descriptive bit about Dave ejaculating was a little telling to me. Rainbows. It's fabulous. I'll bet he knows a lot of show tunes too. All right, we've still got 20 pages to get through.
I forgot. We should be calling him Laura's bitch. That is so much funnier.
Right. Legal
Laura's
vices,
bitch.
Me and Foreigner, double vision. That was one of the very first albums from the RCA Record and Tape Club I bought with my very own money for 1 penny as an 8-year-old. Foreigner, double vision. That was one of my 6.
Oh, can you pull up my super chat by David Gingras because it's hilarious.
Well, let's do that, and then let's catch up because there's only like 4 and they're all yours. So
Okay.
The last one the 3 and they're all for you. Oh.
Robert James, thanks for the 2. Megan, please read my email when you can. I did, and I responded.
Oh, see, we have to see. When I read that, I read it in like, Megan, please read my email when you can. That'd be great.
That'd be great.
That'd be great.
Wait, I believe you have my stapler.
My red stapler. My stapler. Touch my stapler. We'll burn the internet to the ground.
I'll burn this place to the ground.
Oh, and hey, that goes with our next super chat.
Ian Thomas, thanks for the 2. LP begging. I find that offense. What? Offensive.
Oh, I read that. I found that
O-face.
I have.
Offensive is different than O-face, Jeff.
Yeah. Well, I read the first one. Thinking that'd be great, and then O-face. Hey, these go. No, never mind. I guess they don't.
Never mind.
David Gingras.
And David Gingras, thanks for the 5. At name & control shift Megan Fox. There you go, defaming me again. I love the screen fit, the photo. Look at the avatar.
Yeah.
It's Gingras and his best friend, Donald Trump. PC load letter. Oh, man.
Interestingly.
Good times.
At name & control shift. Do I want to? What the hell is ampersand? Ampersand is like the and sign.
Yes.
Control shift.
What are you doing?
What the fuck does it do?
I don't know.
I'm not even trying. Probably, she probably wants us to do that.
You know how Jingy is always typing out hashtag before he puts a hashtag. So that's what that's all about.
Okay, that could be. All right. I'm thinking too much.
You're thinking too hard.
All right, let's get back into this. Thus, according to Clayton, you chat.
Is this my turn or yours? I don't remember.
I think it's mine.
Okay.
I think so. Anyway, I'm going to read it again anyway. Thus, according to Clayton, the existence or absence of a verified ultrasound was the single most important evidentiary issue in this case. I don't think so. Just one small problem. Laura could not provide a verified ultrasound. The reason why is the crux of the problem. And it explains why, beyond question, the trial judge committed structural error.
Does it, though?
I don't think so. Let's find
out. In short, before Laura's petition was filed on August 1st, 2023, Laura provided Clayton with a document she claimed was a sonogram taken in early July 2023 at a facility called Scottsdale Medical Imaging or SMILE. The smile sonogram is found in the record. As part of an affidavit Laura submitted as part of the report of her medical expert, Dr. Michael Medchill, a retired OBGYN physician who was about 180 years old, who was the former chair of the OBGYN department at St. Joseph's Hospital in Phoenix. In her affidavit, oh, this is your paragraph. Sorry, I got carried away.
You got carried away. You were being a woman and going into hysterics. You're getting the vapors. In her affidavit, Laura admitted that, in fact, the smile sonogram given was not created at Scottsdale Medical Imaging. Why doesn't he care
Right
so
to
much
jail,
about,
right away.
why doesn't he care so much about the rule against perjury?
And filing false documents in court. Well, why doesn't he care about that rule?
Smokey, this is not Nam. This is bowling. There are rules.
Hey, well,
Smokey.
I love that movie. I need to rewatch it again.
Rather, Laura's affidavit explained the smile sonogram was taken to Planned Parenthood in California on July 2nd, 2023.
Which it also
Early
wasn't.
July, some different day, different place, different affidavit, she explained. Sigh. Affidavit of Laura Owens, blah, 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 explaining, I committed perjury because I did not want Clayton to know where I had gone for the appointment. To conceal that information, she didn't say that. I just made that first part of perjury. To conceal that information, I modified the image to change the facility name from Planned Parenthood to Smile. And I also changed the date from July 2nd to July 7th.
Putting aside, yes, let's put this aside. Putting aside the extreme lapse in judgment
Perjury.
that resulted, it's just minor perjury, Jeff. For fuck's sake, it's just minor perjury.
But I thought this was the single most important issue in the case.
Putting aside the extreme lapse in judgment that resulted in Laura providing a modified, non-authentic sonogram. Is that another way to say doctored?
I think so.
Non-authentic sonogram to Clayton.
Non-authentic.
Again, before this action was filed.
Sort of like unhoused individual.
Laura steadfastly maintained the sonogram was otherwise genuine.
Mm.
On that
Well,
point,
other than the parts that I forged, it's genuine.
on that point, Laura's affidavit was clear. Other than changing the top part of the image to alter the facility name and date, I did not change any other part of the image. This image was taken at Planned Parenthood in California on July 2, 2023. I did not find this image online. I did not take someone else's image and pretend it was mine. I obviously regret doing this, but I made a mistake due to the amount of stress, anxiety, and depression I was experiencing.
And why should we believe you?
Well, she was proven in court that she didn't go there either because all the Planned Parenthoods in the whole freaking state of California checked their records.
Mhm.
I went there under a fake name.
So
what?
except for that part, I told the truth too.
What? What? It's pretty good.
Yeah, dude, you're getting
what?
better.
this will get awkward.
So stupid. Clearly, because Clayton's expert opined the only way to confirm a pregnancy was with a sonogram. Laura's testimony on this point was critical. If the sonogram was real, big fucking if,
But
the sonogram was real.
It wasn't real.
It was real, except for the fake parts, okay? Except for all the fake parts and the location and the day and the time and everything else. Except for all the fake parts, it's real, Megan. What do you want? Like a genuine nothing is faked sonogram? Well, what kind of fantasy world are you living in? Jesus.
I can't.
If the sonogram was real, big if, Laura's pregnancy was real, of course, because Laura admitted to modifying the original sonogram to change the name from Planned Parenthood to Smile. Clayton understandably did not believe and wanted to independently verify Laura's story. Weird that just because you forged everything about it, except for perhaps maybe the picture, which, this is the thing. It's you lie about one thing, you can assume they're lying about everything.
This is very upsetting. It's very upsetting. That's all I have to say. I hate
Is your
this
anxiety
filing.
over the roof?
I have anxiety over the roof.
But there was another problem, according to Laura. She did not use her real name for the appointment at Planned Parenthood. As a result, Planned Parenthood could not verify that sonogram was taken there. No, what Planned Parenthood verified was that they won't see you using a fake name. So she didn't go there.
Yeah, there's this thing like, oh, dear God, something went wrong. How do we get a hold of John Smith?
The government requires them, because they get government funding, to take government IDs.
Yeah.
It's ridiculous.
Like this person wrote this when he's in the early stages of rape.
Like I said, we somehow won custody of the bad dog in the relationship and in the custody divorce. And I want to give him back now. It's time for him to go back to Woodnick for visitation, because I can't deal with this rabid dog anymore in my house.
Fever dream or Fiverr dream?
She hired Fiverr.
The sonogram was real. It just wasn't Laura. Yeah, we got all the grams, sonograms, ultragrams, ultrasounds. They're all what's the term? They're not all fake. They're all altered.
I'll tell you what it is medical fraud. And if I were
they were all
Smile,
modified from the original. That's what.
If I were Smile, I would be suing her or trying to get her charged under medical fraud for using my company's name to doctor medical records. That is a crime. Okay, it's your turn, I think.
Laura's testimony on these issues was the subject of harsh cross-examination at trial by Clayton's counsel. During the colloquy, Clayton's counsel attempted to argue, using hearsay, that someone from Planned Parenthood claimed Laura's sonogram did not appear to be, quote, consistent with ultrasound images generated by their practice. Their practice, meaning a specific office in Mission Viejo, California, which is located in Orange County.
Oh, we get to do a dramatic reading.
Woo!
I'll be Laura, I guess, because I can do the vocal
You can do
fry.
it better. Yeah. Well, I can't do it. It just sounds weird. On this point, the following trial testimony was offered by Ms. Rina, Clayton's counsel. And while you've indicated today that you went to Planned Parenthood under a fake name, this letter actually indicates that you had scheduled an appointment for July 2nd, but that you failed to attend.
Correct.
It also indicates that the ultrasound image you claimed was from Planned Parenthood was not from Planned Parenthood because it was not consistent with ultrasound images generated by their practice, right?
Not by the one in Mission Viejo. Correct.
Ms. Owens, these are yes or no questiones. The document states that ultrasound images you have claimed is from Planned Parenthood is not consistent with ultrasound images generated by their practice, right?
By that practice, but they said it could have been, I could have been seen by another different entity.
I could have been seen by another different. Were you or were you not? What do you mean I could have been seen by another different entity? Were you seen by someone else and was it a different entity? I could have been. I'm not telling.
It could, maybe.
Ms. Owens, you're well aware that this request covered all of Orange County and San Bernardino County.
It didn't cover Los Angeles, though.
So now you're saying you went to Planned Parenthood in Los Angeles.
Yes.
So you're telling us you went to Planned Parenthood in Los Angeles on the day of trial, today.
Why did he put this in here? Yes.
Because he has reading comprehension problems? I don't know. Okay. When did you go to Planned Parenthood in Los Angeles?
Exactly when I said I went.
When was that?
July 2nd. To summarize the key events, prior to trial, Laura always maintained she went to Planned Parenthood in California on July 2, 2023, and had a sonogram done at that time. Originally, when she asked to identify the specific address of the facility she went to, Laura said she went to a location in Mission Viejo, which is a city in Orange County, California.
Why is this in here?
I don't know.
Why is this in here?
I don't know.
Why is this in here?
Because he can't hide from it, so he has to put it out there and then make an argument about it.
I mean,
it's so bad for her. It's so bad for her. I wouldn't be surprised. I don't know if the appeals court has this power, but if they read this, I wouldn't be surprised if they were like,
Right to jail, right away.
just go to jail.
I mean, the sonogram did not appear, not that it was or wasn't, it didn't appear to be consistent with the specific office in Mission Viejo. You mean the one where she said she went and then she changed the fake name and then she changed the date and then she said she did all of this and then, right here in court, she says, no, just psych, it wasn't Mission Viejo, it was Los Angeles. How does this help you?
It doesn't.
Gingras. How in the hell do you think this makes a judge go, oh yeah, I guess that was a real sonogram? Dude. Jeebus.
He's like detailing all the lies she told. It was just
I
amazing.
know. This is that R word I can't say on YouTube.
Yeah, it's pretty bad. Okay.
At trial. You finish this? Yeah,
I did.
Okay. At trial, when pressed about this claim, Laura changed her perjured herself. Changed her testimony and said the location she went to was actually somewhere in Los Angeles, not Mission Viejo. Why is that address change so important? Because it's fucking lie.
Here's why. Unbeknownst to anyone at trial, because the business hours of Planned Parenthood were never discussed at trial, as the transcript plainly shows. After the trial ended, several of Clayton's fans conducted research which they claimed showed Planned Parenthood locations in Orange County have different office hours than those in Los Angeles.
Citation needed. According to these online sleuths, Planned Parenthood locations in Orange County are open on Sundays, but offices in Los Angeles County are closed on Sundays. This information, if accurate, would appear to directly contradict Laura's claims that she went to a Planned Parenthood location in Los Angeles on July 2nd, 2023, because, as the calendar shows, that day was, in fact, a Sunday.
Again, when understanding this problem, it is essential to consider what a douchebag I am. I'm sorry, to consider prior to the day of trial, Laura never said she went to Planned Parenthood in Los Angeles. She always claimed she went to the Mission Viejo location in Orange County, which is open on Sundays. So, Your Honor, my client told so many lies. She told so many lies, multiple lies over so much time that the judge couldn't possibly have gotten this correct, because the lies were so confusing. The judge completely screwed up because she believed this lie over that lie. And, so acquit.
So weird.
Remand.
Remand, other R word we can. Summarize the brief in one paragraph. A picture is worth 1,000 words. This is why Clayton's counsel rightly expressed such surprise and frustration at Laura's change in testimony. So you're telling us that you went to Planned Parenthood in Los Angeles on the day of the trial today? Emphasis added. Prior to that moment, Laura never said anything about visiting a Planned Parenthood location in Los Angeles, but Planned Parenthood locations in Orange County are open on Sunday. So that meant Laura's testimony about going to Planned Parenthood in Mission Viejo on July 2nd was a non-issue until the very moment Laura changed her story at trial. This isn't helping.
Where is he going with this?
This is not helping you, David.
Where is he going with this?
To the bank to pay $150,000 with his client?
This proves several key points, folks. First,
I wonder if they're the same key points that's been proven to me.
First, it explains why Dr. Deans was never asked about Planned Parenthood being closed on Sundays in Los Angeles. Putting aside the fact that she never claimed to have worked at Planned Parenthood in California and thus lacked personal knowledge of this point, her only work experience for Planned Parenthood was on the East Coast. Dr. Deans had no reason to discuss the business hours of Planned Parenthood in California for one very simple reason. No one in the courtroom had any idea that Los Angeles Planned Parenthood locations have different business hours than those in the neighboring Orange County, nor did anyone realize or mention Planned Parenthood locations in Los Angeles are closed on Sunday. That information was only discovered by Clayton's supporters who posted about it on social media after the trial ended. Where are the key points? What were the key points we were proving again?
That he really, really, really wants to lose this appeal?
She lied.
This is what we're proving, that his client is a liar.
This is bad. The first 39 pages were useless. This is just bad.
Damaging.
This does not mean what you think it means.
Inconceivable.
So it's like, okay,
Inconceivable.
although my client committed minor perjury 843 times, although my client although she lied about the location, the name of the place she got this, although she lied about her name and possibly lied about lying about her name, although she lied about the date this happened, although she lied about the physical location of the place she went, the judge found out that one of the places was closed on Sunday, so therefore you have to throw this case out.
This will get awkward.
Yeah. That's why the real daddy judges above, the ones in the uber authority positions go, yeah, I don't think one thing about a date on Sunday really matters.
It really doesn't.
If you take that away, she still lied about fuck ton of stuff.
She lied
about everything.
Right to jail, right away.
Right to jail.
Right to jail. Right to jail.
This is why, Megan, it is so clear the trial judge violated Laura's rights by performing a secret, independent investigation into the facts, which included reviewing and adopting.
We forgot to do that after secret, independent investigation.
Yes. She violated Laura's rights by performing a secret independent investigation into the facts, just the facts, which included reviewing and adopting as fact statements posted on social media, like everyone else in court who were oblivious to the problem at the time. The trial judge could not possibly have known about the closed on Sunday issues unless she viewed social media posts after the trial was over, because those posts were the first and only instances where this issue was ever raised. TED Talks. Planned Parenthood isn't even open on Sunday in LA.
And then he puts up these social media posts everywhere.
Oh, good. This means we got to skip a whole page that way. Oh, see, we're coming to the end. Only 20 more pages. Yoink.
In light of this evidence, it was plainly wrong. In light of all this evidence that my client is a liar, it was plainly wrong for the presiding judge to suggest Laura offered nothing but mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation. To be sure, because Laura asked for an evidentiary hearing on this issue, which the presiding judge denied, it is impossible to know precisely where the trial judge found the online statements claiming that all Planned Parenthood locations in Los Angeles are closed on a Sunday.
But that doesn't matter. It's clear, with 100% certainty, that the source cited by the trial judge, Dr. Deans, never said anything about the business hours of Planned Parenthood in Los Angeles. Given that fact, and given that Clayton's fame-obsessed fans did vociferously post about this issue online hours after the trial ended, the only plausible conclusion is that the trial judge did exactly what Laura claimed. After the trial ended, she went online and performed an undisclosed investigation into the facts. And then she tried to conceal that misconduct by falsely attributing the testimony to Dr. Deans, who said no such thing. In this way, by performing her own investigation into the facts, the trial judge committed structural error, which violated Laura's constitutional right to a fair trial.
The law supporting this point was discussed extensively in Laura's motion for a new trial. In short, virtually every court that has considered similar facts agrees when a trial judge independently investigates the facts of a case, that conduct constitutes structural error, entitling the affected party to a new trial automatically without regard to harmless error analysis.
Well, they did use the harmless error analysis. So sorry.
Analysis.
The analrapist. The world's first analrapist. Oh, Lord. Speaking of funny things and funny people, we have a couple things here. Is this where we are? I think is where we are. Yes, this is where we are. Matt Red Queen, are there not penalties for false discovery? Yes, that's why she's being ordered to pay $125,000. Given to these courts and dancers on to the lawyer who submits that to the court. The judge just said, hey, you lose, you're getting sanctioned. That's what the judge said. The judge can do it on their own motion. Island for Megan Fox.
Off topic, but my friend who actually had a cancer diagnosis from a doctor and has had a brutal year just found out she's officially cancer-free.
Yay!
Awesome. Fuck cancer. It's great news.
Good job, Island. Tell her howdy. Lone Star Living with the $5. I think if you two read this for the court, the appeal would be heard. It'd be like, yeah, you guys suck. We're granting the appeal to Gingras. you guys suck. One of you is not even an Arizona lawyer, and the other one, like nails on a chalkboard.
Yep.
We can't help it. We are who we are.
We can't help it. Yep. It got to be me.
And you've got to be Strawberry. I gotta figure out why my lens is all foggy. All right. So the Arizona Supreme Court embraces the same standard. In cases involving trial error, we consider whether the error so assessed was harmless beyond a reasonable doubt. If so, we uphold the verdict entered. In a limited number of cases, however, structural error occurs. In such instances, we automatically reverse the guilty verdict entered. Unlike trial errors, structural errors deprive defendants of basic protections, without which a trial cannot reliably serve its function as a vehicle for determination of guilt or innocence. And no, like that ... and no ... punishment. There could be 83 pages missing from that, and we wouldn't know. and no punishment may be regarded as fundamentally fair. I don't like ellipses.
Emphasis added and cleaned up, presumably due to the high ethical standards of most Arizona jurists. Comparable instances of a judge conducting an undisclosed investigation into the facts of a case and then adopting findings based on that investigation as occurred here are essentially non-existent. However, courts in other states applying the same constitutional standards are in unanimous agreement. It is structural error requiring automatic reversal if...
When a trial.
What?
When a trial.
What?
When a trial.
When a trial judge independently investigates the facts of a case. This is so because the bedrock due process requirements of fairness requires that conclusions reached by the trier of fact be based upon the facts in evidence and prohibits the trier of fact from reaching conclusions based on evidence sought or obtained beyond that adduced in court.
Well, again, let's take out let's assume the worst, that the judge did go, open on that day. Let's assume that happened. And you take away that evidence. You take away that entire it ain't open on Sunday thing.
Mm-hmm.
I still think there's a pretty solid case there.
Yep.
I don't think that was the keystone of the argument.
It really isn't. I mean, it doesn't matter whether they're open or closed on Sunday. What matters is she never went.
It was one lie amongst about half a dozen dealing with one wasn't a sonogram. What was it? Ultrasound.
Yes.
Like half a dozen lies dealing with the same ultrasound. So I think if you take away one, you're still pretty good.
Mm-hmm. Thus, if a judge, especially in a bench trial, personally investigates the facts of a dispute or makes findings based on his or her own independent research or knowledge rather than based on evidence admitted at trial, this conduct is a per se violation of the Due Process Clause, which constitutes structural, not harmless error. First, the judge sitting as the finder of fact indicated by her comments during Worthy's testimony that she believed, based on facts not in evidence, that Worthy's statements about the date of Page's death were likely false. These comments disregarded the judge's duty as the finder of fact to make factual determinations solely on the basis of evidence in the record. Second, the judge independently investigated a fact not introduced into evidence, violating her obligation as the finder of fact to refrain from seeking or obtaining evidence outside that presented by the parties during the trial. The Sixth Court of Appeals stated unquestionably it would be impermissible for a trial judge to deliberately set about gathering facts outside the record of a bench trial over which he was to preside.
Dorsey, emphasis added, cleaned up, reversing defendant's conviction and ordering a new trial upon finding trial judge conducted improper ex parte investigation into the facts of the case. Oh, so this is a criminal case, not a civil case, he's quoted.
Interesting.
Yes.
We found case law in Arizona that showed that a civil court judge civil court judges have been able to use Google and such for and not been overturned on certain unimportant matters, like, for instance, business operating hours. Things that are, I think the language was something like readily available information that anyone could obtain easily and quickly. Like that's not Anyway, but we still don't know if she did that. We do not know. And he never provided any proof. Where was I? Or is it your turn?
Where was I? There's just like a whole paragraph of just citations. Of course, judges are permitted to consider facts outside the record if those facts are proper subjects of judicial notice. However, as the American Bar Association has explained, in a non-legally binding opinion, the business hours of Planned Parenthood in July 2023 would not fall within that exception. American Bar Association, formal opinion 478, independent factual research by judges via the internet. December 8th, 2017, explaining a judge may not use an internet search to determine hours of operation of a business, nor are business hours properly subject to judicial notice.
There's case law that says opposite.
This is not law. This is not a case. This is some doofuses at the American Bar Association opining on this thing. This is our opinion. We don't think it should be this way.
Right, but there's actual case law that where it did happen and it was not, the appeal failed.
This internet search violates Rule 2.9c of the Model Code of Judicial Conduct because the restaurant's hours of operation are key to whether the plaintiff could prevail. We're what? We're what? Key to
where
whether
it's
the
key.
plaintiff could prevail?
It is not key in this case at all. It is
not
irrelevant.
at all.
It does not make any difference whatsoever to the case whether or not it was open on Sunday. That piece of information wouldn't change a single fucking thing in this case. So it is totally different. It is totally different than something that is it really is an issue in the case that would cause one or the other to win or lose the case. That is not the case here.
That is correct. It's a useless quotation right there. Because the hours of operation are key to whether the plaintiff could prevail. I hate to tell you this, but as Megan so righteously, indignantly said, I don't think whether or not that Planned Parenthood was open on Sunday has anything real to do with it. It's like the opposite of that. It's like, oh no, there's only 847 nails in this coffin. The zombie's going to escape if we take one of them out. Ain't going to happen. When a judge ignores these most basic principles and conducts an independent investigation, the result is structural error requiring automatic reversal.
How many times is he going to say this?
Safe
this
harbor.
is like the 6th time that he has said this.
Yeah.
Structural error thing. Like, enough. We heard it already. We get it. We get your argument. And so will the appeals court, because they're a lot smarter than me with my childlike 6-year-old understanding of the law. And they're going to get pissed that they've had to read the same paragraph from you like 5 times about this and 10 times about the other thing. Like, seriously, fucking cut it out already. Cut it down. He's
drafting himself into a loss really quickly here.
God, it's so annoying. And I'm not a judge, but if I were a judge, I'd be like, this guy is on my list. He has wasted the court's time. He has wasted everyone's time by making us read 64 pages that should have been 12.
Yeah, we're on page 54 and this should be about 8 pages.
I'm like,
including index.
This is 8 to 12 pages is the maximum that this appeal should have been. He has repeated himself so many times that I am losing my cool. My temper is rising. My heart rate is through the roof. Where's my button?
I have anxiety
well,
over the roof.
that's just like your opinion, man.
I can't take this. I can't take this anymore.
We're not gonna take it. No.
I'm going to get my chancla. I'm going to start hurling chanclas at Jingy because this is just unacceptable. If I were his English teacher, I would be red marking this thing so hard. There would be scratch marks all over this thing.
Well, he wrote it and then red marked himself so hard.
Repetitive, not needed, repetitive. That's what I would be telling with my big red marker. F, you get an F for this.
About your brief.
Fascinating story. Any chance you're nearing the end?
When a judge ignores what?
The chat wants to know if I said chocolates or chalk. I said chanclas. It's flip-flops. All right, sorry. Continue, Jeff.
When a judge ignores these most basic principles and conducts an independent investigation, the result is structural error, requiring automatic reversal. This is true regardless of whether the ex parte evidence found by the judge is true, false, or completely accurate. We conclude that Dorsey was deprived of the basic protection of an impartial judge and finder of fact when the judge independently investigated a factual assertion made by a key defense witness and revealed the results of her investigation to counsel. This deprivation constituted a structural error, which precludes harmless error analysis and requires that we reverse without regard to evidence in Dorsey's particular case. Again, key. That was not key anything. Blah, blah, blah.
Dorsey, emphasis added, cleaned up, citing, quoting, whatever, reversing in a family law case, trial court's order vacating, stalking order, where a judge investigated facts independently. An improper ex parte investigation by a district court is prejudicial when it bases its ruling, even in part, on the investigation and a fact that it inferred from that investigation. Oh, God. Scroll.
Yeah, I was just seeing if that helped anything. No, it doesn't.
Reversing conviction and ordering a new trial before a different judge, where the district court made an important finding of fact, important being the key word, that is not based on any evidence introduced at trial, but rather is based on facts otherwise known or believed by the district court judge. The district court's error is a structural error that requires automatic reversal of the conviction and a new trial, but only if it's an important fact, not an absolutely irrelevant fact that has no bearing or meaning on anything. Jeff,
Exactly.
I'm losing it. I'm losing it.
Losing. Okay. All right. You lost it a long time ago, lady.
I need a coffee break. I'm run out of coffee. I need more caffeine to calm me down.
We're into our the final stages here, I hope. I don't think so, but maybe.
Are we finishing this today?
Well, I think so. I think we can do it.
Yeah, I think we can do it. What
have I done?
What did you do now?
I don't know. I screw everything up. I do everything wrong. Let's see. Where are we? We are on page 62 of 73. And there's got to be like the service.
It's 73 pages? I thought it was 64. Oh my God.
No.
Lock him up. Throw away the key.
Right to jail, right away.
There should be a page limit on this crap.
It's because the first 9 pages were the index, the list of cases cited and other materials.
I would be so pissed if I were the appellate court for making me read this. I cannot even tell you how pissed I would be for making me read. And me and all my clerks would stand around laughing at it because this is so stupid.
So we've got about 8 pages to go, and he double spaces and has really big margins, so we're okay. He's got to have space for his crayons. Is this where we are? Okay, yeah. Although the presiding judge attempted to minimize the misconduct of her colleague by suggesting this singular factual finding regarding the business hours of Planned Parenthood is of little to no importance given the rest of the findings in July 17 ruling sick. That conclusion applied the wrong legal standard. No, it didn't. Key witness, key evidence.
Important
central.
Fact.
Critical to the case.
Critical. Not this. This is the opposite of that.
It was also factually incorrect, given that the issue of Planned Parenthood's hours was vitally important. In what fucking way was that vitally important?
How is that vitally important? Please explain.
Let's assume they're open on Sunday. Let's just give them that. Okay. Magically, Planned Parenthood in Los Angeles is now open on Sunday.
It is still too late to get a subpoena over there to get her alleged records because she waited until the day of trial because she violated discovery by not telling them the place where she went. So how does it make any difference whether they were open or closed?
She could have brought the unedited one to court.
Oh my God.
She could have submitted it as discovery when she was fucking ordered to. Vitally important. Dude, you're not Obi-Wan Kenobi here, dude. You're not going to Jedi mind trick anyone.
Ridiculous.
These are not the hours you're looking for. Move along. It doesn't work here, pal.
Mm-hmm.
Yeah. Vitally important. Megan Fox.
This is so because harmless error analysis does not apply to structural error. Explaining if structural error exists, reversal is required regardless whether the defendant objected in superior court and without the need for any separate showing of resulting prejudice. Structural errors create defects in the trial mechanism itself and affect the entire conduct of the trial from beginning to end, damaging the framework within which the trial proceeds. Ellipsis in original.
For those reasons, this is conclusion suddenly? All right.
Yes.
For those reasons, although this court should not force the parties to waste any further time or resources on a retrial because the safe harbor issue discussed above is dispositive,
Oh, no.
the lower court's judgment must be revoiced because the trial judge committed structural error, which violated Laura's constitutional right to a fair trial.
The award of fees sanctions under the law was plainly erroneous. Citations to record and standard of review. If the court reverses for either or both reasons set forth above, it need not reach any other arguments. However, Laura raised the trial court's erroneous award of sanctions under ARS 25-324 and other authority in her motion for new trial and other relief. What are you laughing at?
You literally trying to power through this.
I know. I can't wait to be done with this. Can you tell? Can you tell? As noted above, the motion for new trial was denied by a one-line minute entry order dated September 6, 2024.
Oh, dear. As also noted above, say Rule 126 one more time.
Say what again? Say what again? I dare you. I double dare you, motherfucker. Say what one more goddamn time.
We need to get AI to say that in his voice, but say Rule 26 one more time. Somebody, please, God, please, DJ Radis, are you out there? Can you please take care of this? We need Samuel L. Jackson to say Rule 26 one more time, motherfucker. One more time. Please, someone with an AI account, please do that for me. Please, I beg you. I beg you.
Oh, as also noted above. No, wait, we've lost a dog.
What?
No, just
lost.
Strawberry migrated.
Okay. Don't say we lost a dog. That you scared me.
Well, shit, one of them just died. What do you know? Crap. Back to the brief. No, it would have been a little more dramatic than that. As also noted above, when sanctions are challenged on factual grounds, abuse of discretion applies. Abuse of discretion applies. However, the legal basis is challenged. Review is de novo. Whether the basis for awarding fees is proper is an issue of law that we review de novo, new all over again. Discussion.
In addition to sanctioning Laura under Rule 26, the trial court also cited ARS 25-324 as a separate basis for a fee award. However, as Laura explained in her motion for new trial, by its own terms, that law does not apply to paternity proceedings. It only applies to the costs and expenses of maintaining or defending any proceeding under this any proceeding. What? It doesn't apply to paternity proceedings. It only applies to any proceeding.
You just went all squirrel from Ice Age. Presume any.
No. This is my internal monologue.
You got whiplash there from putting on the brakes so damn fast on that sentence.
Does not apply to paternity proceedings. It only applies to any proceedings under this chapter of this title. By definition, this does not include statutory paternity proceedings under ARS Title 25, Chapter 6. Oh, fuck off. David, this is ridiculous. Nice dog butt in the camera, by the way. Hilarious.
Oh, cute.
Stop licking each other's ears. Gonna get an infection.
Hey.
Stop licking her ears. Stop it.
It's better than most places they lick each other. So.
You're always yelling at them not to lick each other's ears. My favorite was when Yoda walked on top of Strawberry and literally just put his nutsack on her head. Like,
it's okay because it's an empty nutsack.
Yoda's like, what? What did I do? just kissing my sister.
Teeth.
Sharing love. Potato pig
Lord.
dog love.
Teabag and doggo. Pig dog.
Yes. Yes. When Yoda teabagged Strawberry on stream. It was very funny. And I like how Strawberry just sits there like, yeah.
Been here,
normal.
done that. Yeah. No, you are mocking God. Stop.
What?
Okay. Hell. Right. So I didn't understand a word of this. Or explaining her motion does not apply to paternity proceedings. It only applies to
any proceeding. Yep.
Whatever. I have no idea what that means, honestly. Don't think I care. Oh, she's getting ready to go. He's getting ready to go to a wedding. He's getting his little veil on over there. Hiding behind the curtains. Why is my lens all weirded out? Anyway, the motion further explained that although the correct statute, ARS 25809G, does permit fees to be awarded where a party has engaged in unreasonable litigation conduct, and such conduct necessarily caused the other party to incur fees and costs, the facts here could not support such an award.
Oh, here we go again.
Because once again, Laura attempted to invoke the safe harbor rule.
Even Yoda has had enough. Look at Yoda's face. It's like, not again with Rule 26.
Seriously, Jesus. So, Laura attempted to invoke the safe harbor provisions of Rule 26 by moving to dismiss her petition before the vast majority of Clayton's legal fees were incurred and before any fees were actually necessary. Again, it was undisputed that both Clayton and Laura were pro se from the time the original petition was filed on August 1st, 2023, until Clayton retained counsel, who appeared in mid-December 2023.
What is Yoda doing?
Doing
Look
Yoda.
at him. He's hiding half his face behind the curtain. He got shamed because I told that story about his nutsack. Sorry, Yoda.
We're cleaning the camera here.
Yoda's pouting behind the curtain. Pay no attention to the pig dog behind the curtain.
Now they're all like, oh, I heard paper rattling. They heard this and they go, oh, it must be treats because it made noise. Here. Suck on a wet wipe.
Suck on a wet wipe? That sounds...
Yeah, I was wiping the camera and they're like, oh, it sounds like snacks. So they came running over. All right, dogs, do your thing for just a couple more minutes, then we'll go watch a movie together or something. Right. It's chaos around here. Leave us alone. Big dogs. See, whatever. Just dog butts galore.
They're so cute. Honestly.
They have their moments. Oh, now you get. Oh,
look at they're sharing their little doggy bed. I mean, they are too cute. Don't lick his ear. Look how cute they are. Look at them. Aw.
Yeah, they're okay. I'll keep them around for a while.
They're adorable. Is this my turn or yours? I don't.
I don't know. Let's go. At the time Laura moved to dismiss, December 28, 2023, Laura had miscarried over a month earlier.
Huh? Not July when she passed the weird tissue?
Not
or
never,
October.
She just thought she was.
Or October when she tested not pregnant.
Well,
but a month earlier than December.
Technically, July is over a month earlier.
Oh yeah, you did say over a month.
Yeah,
I'll give him that. Okay.
Technically, he didn't lie. It's technically. Although Laura had miscarried over a month earlier, and the case was set for administrative dismissal, Laura did nothing whatsoever to keep the case active. Once she learned she was no longer pregnant, or once she learned that she would have to come up with a death certificate for 2 babies, and then And then suddenly, like 10 minutes later, realized, oh my God, I'm not pregnant anymore. It must have happened earlier. Wait a minute. Yoink. Right. While perhaps it would have been preferable for Laura to notify the court of her intent to dismiss sooner, this delay did not cause Clayton to incur legal fees.
At the time, wait, all right,
What?
you already read that.
That's the beginning of the paragraph. I'll finish it, then we'll scroll to the next one. How about that? Does that sound okay? All right.
Yes.
The case was already scheduled for dismissal due to a lack of activity before Clayton's counsel even appeared.
Wait a minute. I'm talking now. If you don't mind, please. Does that sound familiar?
If Clayton's counsel had done nothing, the case would have been dismissed without a single dollar of fees incurred by either side. No, that's not true. Okay, never mind. The only reason that did not occur was Clayton's decision to file his Rule 26 motion for sanctions. Like, I can't even argue with this guy anymore. I don't even care. Which he later withdrew. For that reason, there was no factual or legal basis for an award of fees under ARS 25, except that the judge thought there was. So you can just fuck right off, you fuck. Because even assuming arguendo that the original filing of the petition was unreasonable, that act did not cause any fees to be incurred. How does he fucking figure that? Since the action was scheduled for dismissal before Clayton even retained counsel. No, that's not true. He retained Deandra. And Deandra went with him to that second, that he's leaving out the harassment orders. He had to defend himself against a restraining order. He had to he spent like $12,000 on that, maybe more.
Megan, I just can't argue with him anymore. Also, Megan, that's not what happened. Let me tell you what happened.
I know. I have to stop. Stop.
He's baiting you.
Staple my mouth shut.
With the stapler. Similarly, the trial court found sanctions were justified because Laura Owens knowingly presented a false claim, which is grounds for sanctions. Knowingly violated a court order compelling disclosure, which is grounds for sanctions. Or discovery, such that an award of attorney's fees and costs is appropriate under Rule 26. No, must be something else. That holding was also incorrect as a matter of law and must be reversed. Pray, do tell Megan why.
This is so because by its own terms, 25 permits sanctions when a party has presented a false claim under section 25.403, 40303, or 40304 with knowledge that the claim was false. But none of those statutory provisions applied here. ARS 25.403 involves issues such as legal decision-making and parenting time. ARS 25.40303 addresses issues. No, we already looked all these up. And I found applicable things in each one. We already did this. Go back and watch that. Well, ARS 25403.04 permits a court to consider that a parent has abused drugs or alcohol or has been convicted of any drug offense when making custody determinations. Clearly, sorry.
Relax.
I'm trying to get through this. I can't.
Clearly, there was no basis for the court to conclude that Laura knowingly presented a false claim under any of these statutes. There was a simple paternity establishment proceeding, which unfortunately ended without the birth of any child/children. Therefore, there was no basis for the court. Do you like how we've gotten so far into this? That we can just read a sentence like there was a simple paternity establishment, which unfortunately ended without birth of a child. And we just look at each other and go, and then we just, so much is communicated. Telepathy is happening. We're like,
Wasn't there like 800 pages ago an argument about how we couldn't prove she was never pregnant? And now in this page, he's like, there are no babies.
Therefore, there was no basis for the court to find that Laura made a false claim under these things because none of those statutes applied here.
Of course, ARS 25.415 also permits sanctions if a party has violated a court order compelling disclosure or discovery. Yes, we read that.
Wait, you know what we also read? This part up here. That
knowingly presented a false claim.
Yeah, Laura Owens knowingly presented a false claim. So ignore.
Oh. Oh, wait. Also
it
violated a
permits
court
sanction-
order
yeah.
compelling disclosure discovery. But here there was literally no basis for the court to hold that Laura violated any order compelling discovery. What?
Are you out of your fucking mind, dude?
She admitted on the stand to violating discovery.
She disclosed
And
virtually
he put the
nothing
transcript
in
in here. Specifically, in the proceedings below, the court did grant one motion to compel, resulting in a single disclosure order. That order required Laura to provide 5 categories of information, but Laura fully complied with that order by disclosing all required information except for where she went to fucking Planned Parenthood in California.
Well, see, you know what? You have a duty to disclose. You don't have to be ordered to disclose. You have a duty to disclose.
Remember when the judge made her sit there? She made her sign the thing, the HIPAA disclosure in front of her.
The orders to disclose happen when you have when one party believes that you have not given us everything that you should have given us under normal discovery. If they think we didn't get what, and we think they have it, court, we ask you to order them to say what they have and to present it here. Yeah, this is BS. Laura fucking applied. She complied by submitting. I'm so confused.
She didn't comply. She did not give her medical records. They had to be subpoenaed through a HIPAA release by Greg Woodnick's office. She made him expend his time and energy, which is why attorney's fees were granted, because the judge had to force her to stand there. And then she signed the wrong date or name or something on the paper. Mm-hmm. So she did absolutely violate court orders for discovery.
Well, they say, here's this document that shows, here's my ultrasound. I submitted it. It was fraudulent and manipulated and changed, and I lied about everything to do with it, but I complied with the order. So,
and she did not turn over any records of Dr. Higley, Dr. McCool, all these doctors she claimed to have gone to. She forced Greg's office to have to go through the subpoena to go get it themselves, which of course it didn't exist, because what was that again?
She lied.
Right.
Then there was like the other doctors that may not actually even exist, or that exist that may not have actually given that.
They exist, but they didn't create those records.
Yeah. But she complied.
She did not comply. That is false. That is a lie.
She complied. She didn't comply. Indeed. That point is demonstrated by the fact Clayton never brought any motion seeking sanctions. Had he done so, naturally, Laura would have responded with evidence proving she fully complied with every aspect of the court's discovery order. But Laura had no opportunity to offer that explanation because no motion was ever filed seeking sanctions or any other authority cited in the June 17th ruling. That fact alone warrants reversal of the what? There's a thing called logic. Look into it.
I've stopped listening.
Yeah. This fact alone warrants reversal of the trial court's judgment to the extent it found sanctions were proper under these things. Wow.
The award of fees was erroneous because the fees incurred were not necessary nor reasonable. Oh, fuck off. Greg's allowed to charge whatever he is worth, and he's worth $500 an hour, unfortunately, for Laura.
That's pretty cheap.
Here, after Clayton, or maybe it was $650, but it was close. Here, after Clayton applied for fees and costs, Laura objected. Among other things, Laura noted an award of fees was factually improper for one simple reason, because Clayton did not incur any fees prior to the time the case was scheduled for administrative dismissal. Laura also noted that the amount of, and that's ridiculous because never mind. Laura also noted that the amount of fees was patently unreasonable in light of the controlling standard of whatever rule. The trial court never expressly ruled on Laura's objection, but it was implicitly denied when the court granted Clayton's request for fees. Yeah, you could. Yeah, you can do that though.
As noted several times above, when a fee award is challenged on factual grounds, an abuse of discretion standard applies. Court abuses its discretion when its discretion is manifestly unreasonable or exercised on untenable grounds or for untenable reasons. Okay.
You know, if the court had ordered Laura Owens to leave the courthouse and go to the parking lot where she would be publicly beaten with a rod, like caned, that would not have been unreasonable for what she did. So this is just garbage. Okay, I'm looking at locals doing it now.
I'll read a paragraph while you do that. I'll help us along.
Somebody did it. Oh my God, I can't believe it.
Uh-oh.
Wait. All right, Jeff. We get to take a fun little break.
Okay.
Manders, did you do this? All right, here we go.
They say Auburn one more time, motherfucker. They say Auburn one more time, motherfucker.
Now, can you do one for Rule 26? Say Rule 26 one more time.
I gotta write down that address. Fake you. Fake pregnancy.
Fakeyou.com.
Yes. Fakepregnancy.com. All right. Continue, Megan. We're nearing the end.
You have to share the screen. I can't continue.
Lame.
Discussion again. Because this appeal may be fully resolved on other grounds, the court need not address this point. However, it is worth briefly explaining that even if Clayton's position was correct, and even if the trial court had the ability to sanction Laura under Rule 26 or any other legal authority, that does not mean the award of nearly $150,000 in fees was appropriate here.
Oh yeah, all right. Sanction.
This simple. Oh, this is yours.
The simple fact remains that even if Clayton's factual allegations are true, and even if Laura was never pregnant, which she obviously disputes as vigorously as possible, the filing of Laura's petition did not cause Clayton to incur $150,000 in fees and costs. This is so because both parties were pro se during the entire period between the initial filing of the petition on August 1, 2023, and the time when Laura learned her miscarriage. November 2023. Just roll with the date, Megan. Just roll with the date.
I had Clayton's counsel simply picked up the phone. Do you want to have a phone call? In mid-December and asked Laura about her intentions as Family Law Rule 9C required him to do, she would have informed him that she was no longer pregnant and there was nothing further to litigate. Again, at that point, Clayton's fees were literally $0. That is false. That is just simply false. He had already hired Deandra before that. Would Nick... Do you want to have a phone call? Come on and call me.
Oh, no.
You never talk to me anymore. Come on, pick up the phone. I love that song.
Can I continue now?
Yes.
Okay. I'll get through this. There's simply no legal authority of any kind to support what occurred here. Clayton asked the trial court to force Laura to involuntarily continue litigating this matter. And he then asked the court to sanction her for continuing to litigate this matter. The trial court's decision to permit this sham was clearly an abuse of discretion in every sense of the term. For that reason, even if all of Laura's other arguments are rejected, this court should still reverse the fee award in its entirety on the basis the trial court abused its discretion in both the legal and factual basis of this award.
Laura is entitled to fees on appeal pursuant to the rules or whatever, civil whatever. Laura gives notice that she seeks an award of attorney's fees. Oh my God, he wants them to pay her. Incurred in this appeal pursuant to ARS 25, permitting any paternity proceeding award of attorney's fees, costs, appellate costs, other reasonable expenses, and court determines are necessary. As if any judge would award this woman who committed multiple acts of perjury any fees or sanctions at all against the other person. Is he high? What is he smoking? Where can I get some? I need this level of fantasy world in my life. I need this, I think. I would like to escape from reality to the extent that this man has done. He is living in like a whole alternate timeline. It's amazing. What are these drugs? What are they?
I continue. In the proceedings below, Clayton committed multiple violations of the rules of family law procedure, including but not limited to filing a Rule 26 motion for sanctions without complying with the procedural prerequisites of that rule. Of course, Clayton later withdrew his Rule 26 motion after Laura's counsel threatened to seek sanctions under Rule 26 on the basis Clayton's actions violated that rule. Because Clayton invoked the safe harbor rule of 26, Laura is not requesting sanctions against him under this rule. So why the fucker did you bring this paragraph up there?
Now, bring up my screen again.
Wait.
Say Rule 26 one more time, motherfucker. Say Rule 26 one more time, motherfucker.
I'm adding this to my soundboard. How do I download this? I have to figure it out. How do I download? Oh, I got it. The fucker. This is fantastic.
You got it? You downloaded?
I'm downloading it right now.
All right. Okay. Oh, crap.
Rule 26, motherfucker.
Nevertheless, Clayton's other conduct is more than sufficient to entitle Laura to fees. Under this rule, Clayton continued to aggressively litigate his paternity establishment action despite knowing Laura was no longer pregnant. That fact alone was and is sufficiently unreasonable to entitle Laura to fees on this appeal. Megan.
I'm adding things to my stream deck. You have to keep reading now.
No. This is the conclusion. You get to
we're
read
done?
the last paragraph. Yes.
I have to read it. For the reasons stated above, Laura disrespectfully asked this court, because this whole thing is disrespectful to the court, to reverse the trial court's judgment in its entirety and remand this matter with instruction to dismiss the case with prejudice. In the alternative, Laura requests an order reversing the judgment and remanding this matter for a new trial. In either case, Laura also requests an award of fees and costs incurred in this appeal. Signed, Douche Canoe Esquire. And the Pregnancy Faker.
There we are.
Which, by the way, is going to be my first fiction novel. Douche Canoe and the Pregnancy Faker. A romance novel.
Well, let's see what we got going over here. Help us, chat. Help us. Where are we?
We did it. We got through it. Thank God.
Okay. K-Mac clarified that was to say sanctions, not dancers on lawyers who submitted false discovery. Thank you very much. Island for Megan.
Off topic, but my friend who actually had a cancer diagnosis, I think we read this, is cancer-free. Congratulations.
Again.
Really cool.
Marilyn Leos.
Just for saying nutsack. Thanks for the 10, Marilyn. Appreciate that. If that's all it takes, I'll say nutsack all day long. I mean, nutsack. Should I write a song
Yoda is now
about
trying to hide. This is Jill M's.
Is that for me or you?
This is for you.
Oh, Diane Atlin, thanks for the 10. Greetings from Kansas, Fox Den. Well, greetings, Kansas.
And this is also Caroline B. giving Megan some love.
Caroline says, oh no, Megan, so far off her goal, and they won't finish today. They're still going. As I get up, which hasn't been happening all week, Megan needs to stop derailing. Well,
we did okay today because I think we've both been beaten down by this. I warned you all before we even started day one that appeals are boring as shit.
They really are.
They're horribly boring, and this one was exponentially more boring than I thought it would be.
Not only boring, but upsetting. Like freaking upsetting.
Tiffany.
This is the thing about, because he is upsetting. He is just upsetting.
He's exasperating. I feel exhausted by him. I need to sleep I need a 4-hour nap after that. Tiffany. For Megan.
Oh, it's my birthday. Can I get an
You can, and just because I had to sit through all of that, you also get a birthday shot of
nice.
mystery Christmas whiskey.
Nice.
Happy birthday. Oh, God, I forgot I had all that horrible beer and wine in me. It doesn't taste good anymore. Thank you, Tiffany. Cheers for your birthday. And a big for you. I'm bored. I'm not bored. I'm exhausted. I have no more
I
ahs in me.
know. It's incredibly difficult to read him. It's just awful.
It should be punishment. Lone Star 11 with the $2. Shut off your neon sign. Megan needs the bathroom. Just because I shut the sign off doesn't mean I'm giving you permission.
It does not mean anyone has permission to do coke in the bathroom. Nope.
What are you yapping at?
You can rest assured that I will not be doing cocaine ever.
Don't do that. Don't be like douche canoe.
Caffeine is enough for me.
Come here, buddy. Come here. You know.
I am looking. I made the button, but now I can't find it to put it on the board.
Well, while you're looking for that, Natalia, how you doing, Natalia? Hugs, guys. You did it. We did it. Thank you, Natalia. Appreciate that. Lisa for Megan Fox.
Holy flock, you finished it. Check email, please, Megan. Okay, will do. But I'm looking for my button first.
And Caroline B for me. They finished, and now Jeff can go to bed. Yes, he can. Woohoo! Yay me! It sounds like Megan's going to go back to bed too.
Yeah, for sure. I am. It's
Karen Cars 10 with the $5. Sing with Megan, or we are having the babies.
Would Nick, do you want to have a phone call? That's your cue, Jeff.
Hell. I don't know the lyrics. I don't know the lyrics.
Just make them up. Never mind. Just move on. We're too tired to do this.
Carrie Beth Underwood. Gingras ignores the fact that CE filed for non-paternity, which is why the case continued. Well, spoiler, Carrie, he ignores a lot of things. He ignores a lot of things.
A lot.
And I mean, you want to spin your briefs in a way that casts the best light possible on your argument, but just to twist them so exceptionally, like he did with the online search and shit like that. He's not trying to lose the case. He would never do that.
This is nobody the gaslighting motion is what it is.
He's just not a good writer. He thinks he is, but he's not.
He really does. He really thinks he is. And that is unfortunate.
Say rule 26 one more time, motherfucker.
I did it. I did it.
Say rule 26 one more time, motherfucker.
All right. Now I can go and look at my email.
All right. Oh, and while she's doing that, I know we need to wrap it up, huh, doggy? It's 1 o'clock in the morning, and I haven't even played with you today, so I gotta go play with the dog. Anything interesting in the email that we need to discuss?
I'm not sure if I found the right thing, so I'll pick it up next time I stream for sure.
Hi, Teeth. Dog teeth. Here, get over here, Rufus.
I got a lot of emails for some reason all of a sudden, so I'm not sure which one it is.
Yeah, lucky you. So, Megan.
Yes.
What you doing in the near future? What are you doing on Thursday and Friday? What's the rest of the week looking like?
Well, tonight I have a stream with Tug on his channel, so we will be at 8 p.m. again, and we will be on Tug's channel, and I'm sure there will be more ridiculousness in Otter Creek to cover. Bye, Lauren. Nice to see you. Thanks for modding for me today. And I will, 8 o'clock, Tug's channel, be there. I will also be there.
Well, what about Friday and the weekend?
Thursday, I think, we were doing this switching off thing. I'm actually not sure what channel we'll be on Thursday. Normally we're on Tug's. Maybe we'll be on mine at 8. I'm not sure. For the rest of the week, I'm probably going to take tomorrow off during the day because I have been streaming nonstop. And then Friday also probably. We'll see. I don't know. Keep an eye out on locals, folks. You'll know what I'm doing. MeganFox.locals.com.
And for me, tomorrow will be part 2 of the Massachusetts versus Woodward throwback Thursday baby murder trial. Was it her or was it the family? We'll be doing part 2 of that trial. And Friday, I'm debating whether to do either a Phoenix Wright. We haven't played Phoenix Wright in ages. Do a Phoenix Wright gameplay just to chill, or as is more likely, it's time to step into the swamps of Otter Creek again. So either Friday or Monday, we will begin coverage once again of the goings-on in that part of Florida as we look at the federal proceedings. We'll look at the federal proceedings first. And we'll go through everything that has been filed from day one to right now.
Wow. That should be very interesting, Jeff.
We'll start with it seems to have been recently.
It's been incredibly interesting. You've caught up a little bit on the transcripts of the deposition, which have been hilarious. Did you read the order from the judge, by the way? Ordering them to come to Pensacola after that deposition? That was very funny. the judge who was like, I'm pulling this car over now. Yeah. And there are going to be consequences.
Yes, he's upset.
He's not happy. He's not happy.
Nope. And so that's what's going to happen. We'll start with the complaint filed by Jeremy Hales, and we will just march through the proceedings. And then we have Ohio stuff. Then we have the we have the Lynette filings. Then we have Judge Grudge stuff to cover. There's more in that going on from not only the what the Hales stuff, but the tangential stuff, other cases involving some of the Hales people, and then other cases Grudge is involved in dealing with the Gosney family, not that one, the other Gosney. Yep. So we're going to be spending a lot of time in Florida.
Yep.
Yay.
We may be in Florida covering these cases for the next 2 years. I mean, let's just be honest. There's so much to cover. And I'm not going to stop. I don't care what these people are trying to do. They're trying to like destroy my channel and do all this stuff because I'm reporting on this case. And it's like, yeah, I'm not going to, I don't respond to threats. I really don't. And I'm just going to keep doing what I do. That's what I do.
And you do it well. You do it well.
Thank you, Jeff.
Well, thank you for suffering through this for 3 days with me.
Well, I'm never suffering with you because you're always great. It's the content that was pretty awful. But I mean, we had a lot of fun. I mean, come on, the secret word of the day. It's good times. Good times. Not to mention a new button on my Stream Deck.
Hey, room 26 one more time, motherfucker.
you got to send that to me,
Okay, I'll send it now.
I'm excited for the response. That will be amazing. Yeah, about 10 days from now, 12 days from now, we'll get it. Be here, Karen. We'll cover it. And that is it, people. That's it. I'm going to sleep.
Goodbye.
Megan's going to sleep.
I'm going back to sleep too. I'm going right back to bed. I'm going to roll myself up in a burrito blanket and snooze.
Mods. My mods, Megan's mods, thank both of you, many of whom are the same, for all of the super awesomeness you did here while we suffered through this together. And thank you so much, everybody on all sides, for the generous super chats. I didn't hit either of our cards. Anyway, thank you so much for the super chats, the gifted memberships, and all the other stuff that goes on. You guys are awesome. And Megan will see you tonight, her time, and I'll see you tomorrow, mine.
Bye.
Bye, everybody. Have a great one. Lates. Bye.